May I please?
We're not taking any mentioning.
Lord, it's an extreme urgent
No,
motion.
on Friday you mention, we'll see. Next.
My lord, I am for the state, my lord, in this matter.
It a key just say to be. This matter is appearing under the heading to be mentioned. Inadvertent typographical error has crept into order dated 9th February 2026, mentioning the writ petition number as WPA 17102 of 2023 instead of WPA 17102 of 2025. The writ petition number in the aforesaid order be read as WPA 17102 of 2025 instead of WPA 17102 of 2023.
My lord, in this order, my lord directed the petitioner's file is over here, but he is not present, my lord. Petitioner's advocate, my lord directed in this order that to take instruction that whether he has get the money.
গতকাল হ্যাঁ নেক্সট উইকে দিয়ে দিন নেক্সট উইক it will come up in next week. Plan appears on behalf of the petitioner. দেখি দেখি কি বলছে two.
The direction to file an affidavit, lordship.
Affidavit of service, man. It was not served on the state
Now it has
respondent.
been served.
But
Lord, that my learned friend.
only I have served the concerned respondent, lordship. State, your lordship, pass an order to unless your lordship pass an order to serve government pleas are fresh along with writ petition, they have not received because the matter in 2016, old matter. Here's the affidavit of service.
Is you have served or it has not been served as yet upon the state?
Not served yet now.
Not served.
Because unless your order serve only the private, only the concerned respondent only.
Affidavit of service filed on behalf of the petitioner can one of a heading করবেন can one of 2016. যা আছে এখানে affidavit of service filed on behalf of the petitioner is taken on record. Learned advocate for the petitioner seeks to serve upon the
learned government pleader, lordship.
Upon the state respondents through the office of government pleader,
Right.
High Court, Calcutta. Let such service be effected by the returnable date. Affidavit in service be filed on the said date. Mr. Mukherjee, you will file.
I am appearing for the respondent number 2.
Yes, you will be filing in opposition to the.
My lord, in connection with the first item number 2, my lord, yes.
Mr. Mukherjee, Arjun Roy Mukherjee, learned advocate, appearing for respondent number 2, PBSSM, seeks to file affidavit in opposition to the application. Let such affidavit in opposition. The other matters will be coming up on which date?
My lord, today, my lord,
Today are some of the applications.
Yes.
The original application.
3 weeks, my lord, from which date?
Which is the date?
3 weeks, 1 week. There is not fixed date, lordship. Only direction, the 3 weeks.
In the month of March, there is a date.
March, lordship.
Second of March.
Not
second of March.
9 February, your lordship taken up and one matter direction 3 weeks and 1 week.
3 weeks কবে যাচ্ছে?
নিখিল বলে ওটা 3 weeks করে দিতে 706
তাহলে এক জায়গায় করে দেবো। Within a period of 2 weeks, a reply, if any, be filed within a week thereafter. List this matter after 3 weeks. Let it come up after 3 weeks.
Very well, man.
See if those matters. One I have corrected. There was a mistake in the year of the writ petition that I have corrected. It will appear in the next week.
Even not if there is nothing given to exist because the petitioner has got the provisional page.
Just wait for some time. After these matters, I will again call them.
3 is also same, lordship.
Same, man.
Same order.
Service to
Same order. He will be filing opposition.
That's
3 weeks. Same order. হ্যাঁ যা হেডিং আছে we can. হুম
4, 5 to same code.
Well, 4 to
4, 5 and 7,
2
6,
to
7.
7, my lord, all identical.
2 to 7.
Yes, my lord.
All you will be filing
Yes,
opposition.
yes.
2 to 7 same code. Madam, you file the affidavit of service in all the items. 2 to 7.
2 to 7 and your lordship can specific the copy has been served to the government pleader. Only this much direction I need, lordship.
Similar as to the other directions will also follow.
Yes. Yes.
So 3 weeks পরে under the same heading.
2 to 7.
4 to 7 আমরা
Nothing
আছি
here.
হ্যাঁ স্টেটের হয়ে আমাদের সার্ভিস করেননি তো
But no copy has been served
এই
to
যে
the state.
দাদা
No, I'm giving direction for a fresh service upon the state through the office of
2
government pleader.
457
To the office of the.
Government pleader.
হ্যাঁ 16 নম্বর
Start appearing, he should serve me.
In which item you are appearing?
4, 5 and 7.
4, 5 and 7 with direction দেওয়ার দরকার নেই, just upon the learned advocate for the state, Mr. Jawaharlal Dotto.
Dotto will be, my lord, I am to file affidavit then. I am they.
Sorry. Jawaharlal.
দিয়ে দিয়েছি
Thank you.
Deeply obliged.
You mention the item numbers in your slip.
হ্যাঁ
Yes,
Given?
yes yes
ওটাতে শুধু ওই যেটা উনি বললেন, জওয়াহরলাল বাবু বললেন, ওটাতে চেঞ্জ করে দাও। ওদের অফিসে সাবমিট করবে না, টু দি লার্নড অ্যাডভোকেট করবে।
Item
No.
6, my lord, same as item 2, 3 and 4. 2, 3,
6 will be same.
same.
Only Mr. Day is appearing in some of the
4,
items,
5
there
and
is a
7.
change in that only.
Grateful, my lord.
Wanted up. Yes.
This is the applications.
আচ্ছা ওইটা না কন্টিনিউয়েশন হবে অর্ডারটা ওয়ান এর।
No, last occasion, my lord, report has
রেখে দিন, কেউ ফেলে গেছে।
filed.
কেউ ফেলে গেছে, এখানে রেখে দিন।
The petition has
আচ্ছা, জমা।
received the provisional pension.
Nothing remains in the writ petition.
No, only thing is that the monthly pension that has not been disbursed. And
That is not the prayer over here.
no, lordship, the prayer, if you lordship see my the first prayer, this was for my first prayer. That only I am praying that monthly pension be released on the regular basis and gratuity or provident fund. This has not been considered.
Next একটা বলে next একটার মধ্যে লেখা আছে খালি হয়ে যাবে next একটা বলে দেব
Regular monthly pension. Why
Monthly.
this has not been paid?
and I don't know I have only got the report my
ঠিক
lord
আছে, এটা নেক্সট উইকে রাখুন। থাক, নেক্সট উইকে আসবে।
any no
Take the
already
instruction why the regular, the pension has not been released on regular basis.
if my lord direct they will pay my lord if my lord direct
And I'm just saying that the
First, I have to understand why it has been stopped.
I-
Provisionally, you are paying the regular that you have filed the report. But what about the regular pension? No, it has fallen due.
report is not
Yes.
so my lord after 3
It is-
months they are
it is the
paying.
provisional pension, not regular.
Provisional pension, the last she says that she has filed a report till the month of January.
January, yeah, was
So
disbursed.
February has fallen due, no?
Lordship?
February is not due as yet.
No. February is not due. The February is the running.
So what we do, এটাকে না মার্চ মাসের ফার্স্ট উইকে প্লেস করো। If they release in the meantime the regular one,
Lordship.
if February, then it is regularized, so
Regular.
nothing remains in the repetition. এটা মার্চের ফার্স্ট উইকে দাও। Release this matter on 2nd March.
Second March.
my lord
Grateful.
এক নম্বরটা বুঝতে পেরেছেন যেটা কারেকশন
My lord, I am for the petitioner, my lord. My lord, I
This
serve copy
application?
to the government leader, my lord. Restoration application.
How many days? Any delay?
My lord, I filed within time, my lord. I stated everything, paragraph 4 and 5, my lord.
No. Can. It was dismissed for default on
11/8/2023, my lord.
11/8.
Yes, my lord.
Yes, Mr. Shah is appearing for
Yes, I am for the state respondents. একটু petitionটা দিন তো।
affidavit of service. You file the affidavit of service.
I served no copy, my lord.
Why you are not filing the affidavit?
In this matter, I am for the state respondents, my lord.
File an affidavit.
Oh, service আনেন?
Election.
না না, my lord চাইছে affidavit of service করতে হবে।
For the applicant petitioner seeks accommodation to file affidavit of service. Next week, is this matter? After a week, under the same heading. Next week, this will appear.
Lordship.
File an affidavit.
Lordship, একটা এফিডেভিট অফ সার্ভিস বানাবেন এই রেস্টোরেশনটার যে সবাইকে দিয়েছেন। কাউন্সিল আছে তো মুর্শিদাবাদ, আমরা দিয়ে দেবো।
Petitioner, your lordship. The quantum application appearing for the first time, your lordship.
Serve notice. Contented notice to the. Any hearing notice has been issued?
No, my lord. Appearing for the first time.
No, the Pradhan has issued any notice for hearing?
No, my lord. No step has been taken. Not a single step has been taken.
Notice. যেটা থাকে আমাদের। After 4 weeks, this will be listed.
My lord, I apologize. My lord, kindly, this matter will appear after 2 weeks.
2 weeks.
2 weeks, my lord. It will not be completed.
What is the item number?
Item number 8, my lord.
Item number 8 at 2 weeks for a disclosure.
2 weeks
Tuesday and next week.
নিয়ে নিন তো।
Well, I am for the petition, my lord. Last time, my lord's direction was to file the compliance report, my lord.
File the affidavit. It has been complied.
I am for the state respondent, lordship. Order has been complied, but not informed the affidavit, lordship. Just yesterday he sent through mail, lordship.
My lord, may I say something? My lord, can I go through first?
Issue appointment letter. Yes. You have got?
My lord, appointment letter, my lord. Whenever I went to join, my lord, we shall let you. 11th appointment letter issued, not 11th February. And today is 17th. Still, I have not joined. Whenever I gone to the house, well, we shall let you know later on. I have not joined till now, my lord.
Why?
That's why, my lord. Let them ask, my lord.
Why your client is not joining? Now you were agreed by
This
the
is not the
letters not
subject
being
matter of the writ petition.
Yes.
The appointment letter is issued.
Whether
That
he was
comes
joined
in-
or not,
If the appointment letter has been issued, the chapter is closed now. It is up to you to join or not to join.
No, I have gone there. They have not.
totally depend upon the
This
petitioner.
is not proper, sir.
Well, I'm going to keep it only 2 days. My lord. They shall be let you know. Well, I have not joined. My lord.
No, lordship, proceeding may be dropped,
Why you
lordship.
have not joined? That is what I am asking you.
Yes. I have gone there.
What happened then?
Ah.
I have gone there.
And then?
The officer told her, we shall let you know. We cannot give you the place right now. I have gone there.
Where is the appointment letter?
Well, appointment letter. Same, my lord.
Oh, same.
That appointment letter I have
He
got.
did not get any copy.
No.
He
Hard-
moving the application, lordship.
No. Hard copy, my lord. They have sent through post, my lord. Well, this thing. But my
But
lord,
everything was done, lordship. Kindly drop the proceeding,
gone
lordship.
there, my lord. Why not I go
Then
there?
if the new cause of action arises, then file
No, my lord.
another writ
I
petition.
don't know. Why is it?
What is the order, lordship?
I-
Kindly see to consider the representation, lordship,
No.
and take the appropriate step. And all step has been taken.
Let
Even
me-
the appointment letter was issued,
Well,
lordship.
I have
Then
gone
what
there. I
remains?
have gone there to join, my lord. I have gone there to join, my lord. They said-
Thereafter he come,
শেষ করতে তো
petitioner
চার
come and
শেষ করতে দাও।
lordship
দুটো কথা বলবো।
to submit the, not to get any salary, lordship. That is not the subject matter of the writ
I
petition.
have got the appointment letter, my lord.
What is saying?
Whenever I gone to the office, my lord, they told we shall let you know later on. Appointment letter is issued on 11th February. I have gone there. Then and there I gone there, my lord. Till now I have not been joined. That's my submission.
But the proceeding,
Where is the appointment letter?
Joseph can deal with same, my lord. What letter is handed over to my lord? Same, my lord. Same letter, my lord. What my lord has handed over to you, my lord, same letter.
Dada, এটা
When I am unfair, why not I go, my lord? I go there. Now, every day I am going there. Every day.
Every time you are going there, you are complying the directions of this appointment letter.
Well, I've asked them.
Huh?
I've gone there with this letter, my lord.
the proceeding
Not with this letter, sir.
enough
In
is
the
enough.
last portion of this particular letter, there is a direction.
Yes.
Collect the employment exchange card. Have you produced that?
Everything is produced, my lord. That's why they are.
No. If you have complied, then why they will not allow you?
My lord, that's they. Well,
Sir,
what they are
advocate for the petitioner seeks accommodation. Sir,
Well, proceeding
Order
not
dated
in all step. It is not the problem.
saying, শেষ করতে দে রে ভাই তো বললি আমিও বললাম জশাব যেটা
order
দেবে
of the
It's not
executive
the way.
officer Birbhum Jila Parishad and District Magistrate Birbhum dated 12th February 2026 is taken on record. The highest officer of the district, the
Yes.
district magistrate has issued the letter asking you to join. Then the subordinate officer will restrict you from joining.
I have gone there, Mother. Why should I tell a lie, man?
Or which office you are going to join?
Same office, Mother. Video one.
BDO will stop him. District magistrate passed an order.
Not stop me. We shall let you know later on when we'll join. We shall let you know when we'll join. That
This
was
is
it.
not the
I'm
letter.
not saying.
You will not say
I'm
kindly
not saying.
Drop the proceeding, thereafter.
I'm not saying.
Taken on record. And district magistrate Birbhum designation to দিয়েছেন তো?
ভুল বলছি না ভাই আমি কেন
Executive
আসবো
officer
বলতে হবে
Birbhum Jila
তুইও
Parishad
ভুল
and
বলছিস
district
আমি
magistrate
কিন্তু
Birbhum.
জয়েনটা করি আমাকে দেয় না
Join করে thereafter you
আচ্ছা আচ্ছা
before the after making the
আর
salary.
রেগে
Then
যাচ্ছিস
the
কেন
proceeding
Or
will be
Mr.
dropped.
আর রেগে যাচ্ছিস কেন
What
রে
is
ভাই?
submitting lordship?
আরে মকলিজে দুটো কথা বলবো না এত রেগে গেলে হবে
রাগার question.
এ কি কথা
Order has been complied, fully
তুই
complied.
জয়েন করি আমাকে একটা কাগজ দিয়ে আমি বলে দেবো
কেন আমি
So and so, an advocate for the
তাহলে-
applicant submits that the applicant
আমি
has
আমার বক্তব্য জশাব
gone
যা
to the
বলার
office
বলবে
of
ঠিক আছে
the office has instructed him that they will let him know the date of joining. He seeks accommodation. This matter 10 দিন পরে date দাও। After 10 days, একটা date. Oh, Mr. Bipin Ghosh, learned advocate for the alleged contemner, submits that the appointment letter has already been issued. On which date? On 11th.
হ্যাঁ
11.
On 11th February 2026. 2nd March.
And all is possible step has
Well,
been taken.
well,
Pursuant to your
well,
lordship
well,
direction,
well,
Have
lordship.
been taken.
Pursuant
Well, I am saying I have applied last 10 years for this post. I am moving pillar to post. That's why, my lord. Why should I come, my lord? If I join, why should I say all this thing? তুই বল না
It is
একটা
not
কথা
the duty of the court.
তুই জজ সাহেব বুঝে তুইও বুঝে নিবি এখানে বসে জজ সাহেব
হ্যাঁ,
বুঝে
How
জজ
many
সাহেবের
days
duty।
this will go on? I don't understand.
Well, step has been taken, lordship. Pursuant to your lordship direction, then what remains?
জজ সাহেবের ডিউটি তুই
Now, who
বুঝে
will
নিবি,
take
জজ
you to
সাহেব-
the office of the Jila Parishad to join now?
11, my lord, this is my application, madam. The order in earlier occasion, my lord, this is a content application for the first time. In earlier occasion on 22nd day of April 2025.
Any notice has been
Your
issued?
lordship,
Any notice has been issued of hearing?
I have served the notice on 24th day of July 2020.
No, in contempt, any notice has been issued?
Yes, contempt notice, I have also issued the contempt notice. That is, my lord, the page 90.
After filing, any direction has been issued for survey?
অ্যারো গ্রিপটা একবার দেবে
No,
After,
this is first time.
this is for the first time.
A notice, no, I am asking you whether any hearing notice has been issued.
No, I have not, they have not taken any step.
Okay.
They are sitting, they are absolutely
Notice
sitting
karo,
tight over
4
the
weeks political list karo. Ascertain there is a service upon the alleged contemner.
Yes.
Huh? Not that it is served upon some of
Yes,
the.
I have served, I mean,
No, whenever you file, you ascertain that it has been served upon the alleged contemner.
এবিলিটি সার্ভিস দিয়েছো তাহলে তো
After 4 weeks, this will appear.
I have to serve the.
Yes.
But
Sir.
in other code, the system is quite different. That After admissions of the application, there is a direction to serve. I have not served. If your lordship,
I have given direction.
yes, my lord.
After 4 weeks, this will appear. A
Yes.
direction is given for service of notice upon the alleged contempt,
Along with
the copy of the application.
I'm grateful, your lordship.
Applicant's petitioner, my lord. My lord, the contempt number one was served and effected service was there, my lord. Your lordship was pleased to direct me to serve upon the contempt number 2, my lord. I have served, my lord. But I have checked up, but every service is not ready. I have checked, but delivered, my item delivered. Again, I have served upon the contempt number 2, my lord, pursuant to your lordship's direction, my lord. And I have served, my lord. He received.
Where is that?
But affidavit service is not.
Lord,
ready, but I
advocate
have
for the
checked up, my
petitioner
lord.
seeks accommodation to file affidavit of service. Please this matter after 2 weeks.
My lord, 1 week, my lord. My lord,
1 week. also.
Delivered, my lord. Item delivered, but only affidavit service is not ready, my lord.
Next week.
That-
The first time contempt, my lord, no service.
It is issue notice 4 weeks. Any hearing notice has been issued?
No, my lord. First time contempt, my lord. First, no service has been effected till the, my lord.
Where is the order?
7th May, my lord, the order, impugn order, my lord, passed, directing the, my lord, respondent number 7, my lord, to with certain direction, my lord.
After 4 weeks, serve and file affidavit of service.
Yes, my lord. I am for the petitioner, my lord.
That's why I'm for the DPSC.
Report.
They are for areas salaries, my lord. All proceedings already completed, my lord. And even today is big for submitting report by the department regarding deficit court fees.
Submitted. You have deposited.
My lord, kindly.
For
If-
this, the deficit
in
court
the-
fees under
in the
filing number
circumstance-
this has been deposited. Okay. How many petitioners are there?
8.
8.
Yes. In the similar circumstance as the petitioner, your lordship shall order. I have already submitted them.
Who is for the
I
state?
pray for similar one.
So I am for the DPSC Purvo Mendipur.
What is
Lordship, report has already been submitted.
report submitted?
Yes, Lordship.
Report submitted. Finally, dispose the application by directing the respondent authority regarding disbursement of the areas.
Has not paid to him. This is from which date to which date?
On the
In para 9. February 20th January.
Paragraph 9.
9.
Paragraph 9. Due period.
Hmm?
Due period, paragraph 9.
In respect to petition number 3 and 6, why the period has not been mentioned, from which date to which date?
You had not mentioned, my.
No.
Mention.
Petitioner number 3 and 6.
Paragraph 9. Paragraph 9.
Tally paragraph 5 with paragraph 9. Diga circle.
Total period is given.
No, I'm asking you why the date has not been given.
Date is given in the, my lord, paragraph 5.
9, why you have not given it?
9. Deep.
This is DPSC Jhargram,
Yes. No, DPSC.
Purbo Medinipur.
Yes.
আসো। এই অর্ডারটা দেখে নেবেন, এই অর্ডার। হ্যাঁ। They are similarly circumstanced
Yes, loss.
by the present writ petition. এটা দিচ্ছি না কেন, রিপোর্টটা আগের দিনে দিয়েছে। তাহলে ফার্স্ট প্যারাগ্রাফটা হচ্ছে না, বাই দি প্রেজেন্ট রিট পিটিশন দি পিটিশনার সিক। আচ্ছা, তার উপরে একটা করুন, produce the report of assistant registrar 8 dated 16th February 2026. Next paragraph, it appears from the aforesaid report that deficit court fees have been paid by the petitioners. By the present writ petition, the petitioners seek direction upon the respondent authorities to disburse the arrear of salaries of the petitioners as stated in paragraph number 9 of the writ petition, who are discharging their duties as assistant teachers in different primary schools under District Primary School Council, Purbo Medinipur, which is more fully described in paragraph number 5 of the writ petition. The petitioners joined in their respective schools on and from the dates as mentioned herein below. ওখান থেকে নেবেন, প্যারাগ্রাফ নাম্বার 5 থেকে বলে দেবো নাকি? 5, এই যে petition number 1 first join নয়, joined on 11th week, এখান থেকে এই যে joined on তবে বি এরকম করে, হ্যাঁ এই যেরকম আছে A B C D E 8 জন আছে তো। 8 petitioners are there. 8.
My lord?
8.
Yes. ঠিক আছে।
তারপরে প্যারাগ্রাফ,
Respondent number chairman, my lord. Actually, that is respondent number.
the petitioners did not receive salary from the date of their respective joining till 31st August 2014. Being agreed by such action of the respondent authorities, the petitioner preferred the present writ petition. Submission same, Mr. Ranjan Sahar জায়গা ওনার নামটা নেবে। For District Primary School Council, পূর্ব মেদিনীপুর। State কি আছে? State, you are appealing for the state?
Yes, ma'am.
বাকিটা সেম। স্টেটের কিছু প্যারা নেই। Leave the matter to the discretion of the 7 same accordingly directed. A, petition number 1, 2, 4, 7 and 8. কত বললাম? 1, 2, 4, 7 and 8 shall be paid salary for the period on and from 11th February 2014 till 31st August 2014. B, petitioner number 3 and 6 from 20th January 2014 till 31st August 2014. C, petitioner number 5 from 13th February 2014 till 31st August 2014. Positively within a period of 1 month from date of receipt or copy of this order by the District Primary School Council, Purbo Mednipur. And District Inspector of Schools, P, Purbo Mednipur. Together with interest at the rate of 8% per annum from 1st March 2014 till the date of actual payment. अब ये 10 এর চেয়ে থাকে সার্ভিস। ওকে, ডিসপোজড অফ।
Yes, my lord. Same matter, my lord.
I'm for the state, my lord.
Same prayer.
All right.
Same prayer, same order. This is DPSC?
I'm for the DPSC.
DPSC Purbo Mednipur?
Yes, ma'am.
A report দিয়েছ?
Submitted by the DPSC.
এইটা নিয়ে নিন তো।
কপিটা দেখি করে কপিটা।
annex করে। Executive order why? Where is it?
ফাইল গুলো
আর বহুবার রিপ্রেজেন্টেশন দিয়েছি অমুক করেছি একটা মনে নেই একটা পেয়ে জানতেছেন
Really?
তাই দেখলাম মুখে যেতে তাই
Receive that.
ইচ্ছুলি
সেম অর্ডার, শুধু এটা দেখে নি একটু আর কবে থেকে আছে।
তুমি গেলে আপনি পরে সব বসে চেষ্টা
এটা হচ্ছে প্যারাগ্রাফ নাম্বার, এখানে 4
সব থেকে
ওখানে 5 ছিল,
6-7 মাস করে টাকা
এটা লিখুন 1 petition number 1 19 January 2014 to 31st August 2014. Petition number 2 3 5 6
আমি একজন না আমার নাম
7 2 3 5 6 7
নাম লিখে
11th February 2014 to 31st August 2014. Petition number 4 13th February 2014
লিখে না
to 31st August 2014. Petition number 8 20th February 2014 till 31st August 2014.
এটা নয় সেই জন্য বলছি
চল
আমি এটা নাও না
হ্যাঁ আগেরটা মতোই হবে শুধু এটা পিরিয়ডস এটা
নেই নেই
ডিসপোজড অফ
মাই লট এই লট চল 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 ওই যেটুকু দিচ্ছে হ্যাঁ হ্যাঁ শ্রীলঙ্কা মাইজার জঙ্গল হয় না কি করব
16 minute application. On last occasion, in that was these two, grant will leave to file a supplementary affidavit, may I permit to file? In the case of the petitioner, his father was working as a group D employee of a primary school. Now he retired from the service, but no service benefit has been granted. Retirement benefit has been issued in his favor. Subsequently, his father died. The daughter was dependent upon the father of the petitioner, but no family pension has been disbursed. Now, last occasion, the state as well as district primary school council has filed a report that they did not found any record regarding the service of the father of the petitioner. Now, I filed a supplementary affidavit to bring the documents which I have in my custody. But kindly come to page 5. This is my initial appointment letter of 1968.
My means your father. Your father?
Father, Sivadash. And thereafter page 6, which shows the administrator of that particular school where they were working has issued a letter directed the father of the petitioner to join in the office of the chairman of the district primary school council, Malda. The last line, Shiva Das joined the chairman council, Malda. This is a letter of 1994. The school was closed due to shortage of students, and the staffs of the school were posted in the various other institutions of that particular district. And the page 7 is the last letter which the father of the petitioner received in the year 1995 regarding his superannuation. In
Issued by
in the petition that his date of superannuation is 2009.
Enter.
I'm sorry, madam, but the actual date of superannuation is 31st January 1996. Now I will kindly come to page 13 of my writ petition. Page 13 of my writ petition, it is an order issued by the Director of School Education by which the father of the petitioner was absorbed with effect from 1st January 1969. Now, if they did not find any record, if they go by this particular document, then also the father of the petitioner was entitled to get superannuation benefit because he has completed his 10 years qualifying service. Because no contrary statement comes from the state that the father of the petitioner was terminated or he resigned or anything.
The joining letter was
1968.
no joining letter.
Joining letter.
Where is that?
That is at page 5 of my supplementary affidavit. At that time, the school was organized school, not recognized. Subsequently, pursuant to the order of the Honorable High Court, the school was recognized. And the service of the petitioner, father of the petitioner, along with the other employees have been regularized.
No, this is an appointment letter.
Issued by the school, because at that time the school was controlled by the organizing committee. The school was not recognized.
Okay. No, you have joined. Where is your joining letter?
Well,
You have been
joining
asked to
letter I
join.
don't have. I have only the appointment letter.
Appointment letter does not prove the fact that he has joined.
But his service has been regularized. At that time, because it's a very old document, 1960, 1992, his service was regularized with effect from 1st January 1969, which is appearing from page 13 of my writ petition.
68 he joined.
68 joining, they have given the effect from 1969.
Yes.
Just now, my lord, I have been given, my lord, this supplementary. And if my lord will,
The service books are kept by which authority? DPSC or the state?
my lord, first, my lord, for once, IPLA Pulli Shomiti, my lord, that the supplementary page 5, appointment in the post of Darwan Kam Mali as a school mother training center, Pipla Malda. As directed by the managing committee, you are hereby appointed in the post of Darwan Kam Mali at school mother training center, post Pipla district Malda. You will drop pay and allowances as fixed by the department. You are requested to join the post immediately. My lord, and the next, my lord, page 6 also, it is the administrator sending to the director of school education. As per your memo data such as your ownership directed to absorb the following candidates such and such. Among the above mentioned candidate, Tagore Prabha joined the primary school, and she joined Shobhanagar teacher training. Biton Banerjee, Shivadas joined such and such. Now, my lord, may I come back with the instruction, because this particular supplementary just now has been served upon me, and my lord, what the annexure of the writ petition, my lord, shows, my lord, page 13, page 14 is the relevant. When it was, my lord, service was shifted, page 14, my lord.
Yes.
As per proposal made by the school education director, government of West Bengal, his service so long in mother teacher training Pipla has been attached to the chairman Malda district primary school Shobhanagar, Malda with immediate effect. So long in mother teacher training Pipla has been attached to the chairman with immediate effect. He is requested to get in touch with the authority concerned for getting absorbed in the establishment proposed. My lord, as it appears that as there is a my lord, this mother teacher training center Pipla, my lord, from that center it has been shifted to the my lord, directed to be shifted to the Malda DPSC as it appears from the my lord record. Then, my lord, these documents, as he thereafter he continue in that particular school itself.
No, my lord, that is not correct, my lord. I have stated.
Then that's why, my lord, I am the state and the DPSC, my lord, I am coming with the instruction. I kindly give me some time, my lord, so that I need not to, my lord.
No, any report will be necessary from the state authority.
Yes.
The answering respondent is only the DPSC.
Now, DPSC, in the DPSC, school is coming, and this is a one kind of training center. If that be so, my lord, it is coming under the jurisdiction of DI primary.
That was observed by absorbed by the district primary school, by the West Bengal Board
My
of
lord,
Primary Education. So it comes directly under the district primary school.
That's why, my lord, this
State has filed any report.
State also filed a report saying that we are not finding any document of regarding his subsequent joining.
My lord, 5 persons have been shifted from that particular school.
And, my lord, another issue.
Got their retirement benefit.
Another issue, my lord, the DPSC in the same tune has given because everything has been searched out, that not a single scrap of paper they are getting. Now, this because this issue has to be sorted out, Malot. These two after Malot going through this supplementary, then over this Malot instruction is to be taken. Then we can come back. Let the state be also directed, Malot, so that
Supplementary affidavit filed on behalf of the. This is not an appeal. This is not an appeal, Mr. Mujumdar. You have written for the appellant.
এটা appeal লিখেছো।
By the petitioner is taken on record, copy served. You have served upon the state also?
No, my lord, I will serve. He is not appearing today, so I will serve.
Copy served upon learned advocate representing DPSC, Malda,
Yes, Malot.
Malda. Learned advocate learned advocate for the petitioner is directed to cause service of the supplementary affidavit upon learned advocate for the state. Both the DPSC Malda as well as state respondent is directed to file press report with regard to the documents annexed to the supplementary affidavit. Be specific on the documents he has annexed.
Yes, Malot.
If necessary, he says that you, in page 7, says that as per service book, it starts with the sentence as per service book. If necessary, let the report come. If necessary, the service book can be produced.
Yes, because
which will show that whether he or she has joined.
Only one thing, Malot. This is a Malot communication of 1995. Now, as per Malot information given regarding this particular training center, as of now is no more in existence. As of now is no more in existence. Therefore, Malot, as it is a 1995, Malot, and the service book is the custodian of the service book of this particular training center. Let me, coming, Malot, I am giving a report to that effect. And
after 4 weeks for record. Is this matter after 4 weeks? After 4 weeks?
Yes, Malot.
Final report. Under the heading এটাকে সরিয়ে দাও তো মোশন থেকে।
I'm getting.
মোশন থেকে সরিয়ে এটাকে হিয়ারিং এর একটা ডেট দেবে 4 weeks. Under the heading hearing.
I'm getting.
I'm for the petition led by Mr. Dipenu Chatterjee, madam.
While petition is taken on record, none of you are DPSC.
I am paying for the DPS.
The paying for the petition has a copy of the. What is this?
My lord, on the last occasion, my lord, supplementary affidavit is filed before your lordship regarding the petitioner's medical report, my lord.
Supplementary will not serve.
My lord, our last week.
That a copy of. No, it was submitted on behalf of the petitioner. That supplementary affidavit has already been served.
Already served, my lord.
Served. Supplementary will not serve.
On the last occasion, 10th February 2026.
Hey, supplementary will proceed.
How much?
You have given a copy?
My lord.
Well, as per record, he has served, my lord, but I checked it.
This is not available to you.
Yes, Lord.
Ask from the DPSC.
Yes, yes.
If it is served, ask from the DPSC.
Yes, yes, yes.
What is that case? অসুস্থ হয়েছিল সেইটা মনে হয়। What is your submissions?
My lord, On previous order, 19th January 2026, my lord, the petitioner was extended the benefit of the order passed WPA 20996 to 2022, dated 25th April 2024, and the appointments were directed to the given to the two candidates who were called for interview and who filed the writ petition before 24th April 2024. By the notice dated 29th April 2024, the candidates were asked to appear before the respondent number 3, which is DPSC North Chobbish Parganas, for verification on 13th May 2024 within 5 p.m. The petitioner failed to appear since he was suffering for appendicular lump, which had to be subsequently operated. He seeks to be filed the supplementary annexing the medical documents relating the operative measures undertaking during the said period. The supplementary affidavit is, my lord, comprising the discharge certificate of the petitioners, my lord.
I shall take instruction, my lord.
Yes, the previous Mr. Counsel and Advocate representing DPSC North 24 Parganas seeks to take instruction. Is this matter? Last week ছিল কি? On 2 সপ্তাহ পরে ডেট বলো তো? 9?
9th one.
Therefore, my lord.
Lord, item 18, kindly have a look at paragraph number 7 of your lordship previous day order.
কোন অ্যাকাউন্টেন্ট জেনারেল পার্টি আছে?
তো অর্ডার ওই সিঙ্গেল না না ওই এতে আছে।
One of Justice Ogodo Bhattacharya and one of Justice, the Honorable Acting Chief Justice, the now Chief Justice, my lord. Kindly have a look at paragraph number 6. Mat number 2211 of 2025. Paragraph number 6, last portion. If tribunal was not functional, it was obligatory on part of this court to hear the matter, otherwise the party will be remediless. So, my lord, there is no embargo on your part to hear this matter. No.
Is obligated to part of this court.
এটা চিফ জাস্টিসের এটা তোমার
চ্যালেঞ্জ করেছে জাস্টিস ভট্টাচার্য অর্ডারকে চ্যালেঞ্জ করেছে
না না দুটো আলাদা
আলাদা আলাদা আছে।
No, what is the challenge in this order?
the petitioner before your lordship was
As says the order dated 15th, whereby application filed
বলেছি
and at this stage repeal not maintainable against the repeal. Secondly, the matter
অনেক বড় লাগে
and in this paragraph,
paragraph number 6, the order passed by the Honorable Chief Justice. Mat 2211 of 2025. This is of Justice Ogodo Bhattacharya.
আমরা একদম অ্যাকাউন্ট জেনারেল বলেছে তো ওটাই
নামটা দিয়ে দে
দিয়ে দিয়েছি টাইম নেই
আর অবজেকশন
নাম দিয়ে দিই
added respondent.
ওখানে সার্থকে পাই তারপর হ্যাঁ আমাকে সোনালি
এখানে নামগুলো তো লিখে পাঠায়
Yes. What is your prayer?
To release the family pension.
Where is your make a representation? Or?
Representation, my lord. No.
Not yet made, no? Representation made?
No, my lord. But if the lordship, honorable High Court is entitled Group 6 matter, my lord. If there is no determination, yes, lordship, presently your lordship no determination Group 6, my lord. If a lordship take on the matter, I have no objection, my lord. But
this will be under Group 6.
Group 6.
Group 6 কি করে হবে? Group 2 DI
আরে যদি স্যার যদি না হয় তাহলে তো এখানে হবে গ্রুপ 6 এ
ওই গল্পই আসার কথা না তাহলে
it is direct. It is
No,
matter of
if
the
it is under district primary school council, he is no.
He is her father was the employee of DI primary, the DI of school primary education.
মালদা
my lord.
It is not, and that is the Malota misstatement that he has made in the writ petition.
Yes.
And the DI has Malot already given a report, Malot, that is on record, where he has stated Malot he was the employee of that particular
This will
DI of
go
the
under Group 6.
Group 6, my lord.
as it is a government
Yes,
employee.
direct government employee, my lord, under the DI.
Ashok. In terms of the previous order, learned advocate for the petitioner has placed the decisions of this court passed in Muhammad Masjidul Islam versus State of West Bengal and others. As well as Arnab Adhikari and others. Contending that since the tribunal, state administrative tribunal is not functional, the single bench, the learned single bench of this court can entertain the writ petition relating to service matters. Learned advocate for Mr. Abhishek Prasad, learned advocate for DPSC Malda, and Mr. Tarun Kumar Ghosh, learned advocate for the state, indicates that in that event, this court lacks the determination since the matter needs to be placed before the court having determination under group 6 in view of the what school education group 2? What group 2? But have you gone through the reports they have filed? Is it primary school? Consistently, it has been stated that he was a group 2 under the control of the district inspector. Then, under the district inspector of schools, he is a primary school or a government employee. If it is a government employee, it goes to group 6. If it is under DPSC, then it comes before this court. If you want to argue on this, I will hear you. If you are dissatisfied what I am saying, then you argue on this matter will be whether group 2 will apply or group 6 will apply or give you opportunity to hear this matter.
My lord, I am the Abdus Salam. My leader is Tarun Kumar Ghosh.
Oh, Abdus Salam. In view of the submissions as advanced, the matter is released from the list of the scope for want of determination.
I'm good. Thank you. And I am for the stage.
Exception.
In terms of your lordship direction, lordship, I have observed a copy of the exceptions to the and the advocate appeared on behalf of the respondent. The exceptions to the report. Also, the petitioner was appointed in the year 1991 for the post of assistant teacher in a primary school. Now, lordship, the petitioner subsequently, in terms of the lordship, order of the concerned chairman, lordship, took admission in the training course because petitioner was appointed as an untrained teacher. Now, lordship, kindly come page 34.
Page
34 of the writ petition. This is the order of the concerned chairman, Birum District Primary School Council, Birum District Primary School Council. That is page 34. Now, lordship, relevant page at 36. Serial number 78. Petitioner was permitted to take. No, 30. The kindly come.
74.
Serial 36. Then kindly 36. Serial number 74.
Yes.
Petitioner was permitted to lordship took admission in the training course. Now, petitioner duly admitted to the concerned teachers training institute and completed the same successfully. Kindly come page 40. Lordship, kindly come to the date, page 40, that 17 June, top. 17 June 2006, petitioner has completed his training, teachers training from the concerned training institute. Now, petitioner submitted application for lordship the A
So
category.
the certificate or the results have been declared on which date?
2011.
11.
Now, lordship, kindly come page 47. That is the result, examination schedule. Examination completed in June 2006. Examination held. Training completed June 2006. Examination held on 10 January 2011. That is page 47. That is the examination schedule.
Page 40?
Page 47. That is the examination schedule.
that conduct of primary teachers training examination 2006. Kindly come, the subject. Page 47. What was the subject? Conduct of primary teachers training examination 2006. Sessions 2005, 2006.
Now you have been granted A category from 19.
From 19.
It will be from the date of conclusion of examination.
My respectful submission is I am entitled to get the A category scale from the date of completion of my training, because due to several court cases,
Yesterday, in similar matter, a person has retired from service and he was claiming A category from the date of joining, but that was a coordinate bench has passed an order from the date of conclusion of the examination.
Also, I have annexed some orders that there is the issue has been already held that I am entitled to get the A category scale from the completion of my training. Also, let me demonstrate this issue. Also, kindly come page 47. Let's see what was the examination held in January 2011. That is conduct of primary teachers training examination 2006, sessions 5 and 6. So let's say 5 and 6 sessions examination held in 2011. Now let's say kindly come page 48. That is the government order. Page 48.
Yes.
Now I am relying upon clause 3. Teachers who have attained 1 year / 2 year diploma in elementary education from the state recognized institution and appointed as a teacher on or before 31st December 2005 shall be treated as a trained teacher. Now, Lordship, this is the only provisions, Lordship, for which I am entitled to get A category scale. That who have been trained and Lordship appointed prior to 31st December 2005. This date is very relevant. The petitioner is within this zone of Lordship, the cutoff date, that is 31st December 2005. Now, Lordship, kindly come. The first order in the 2023, what was the order passed by the learned coordinate bench? What was the view? Page 50. Prior to order of the Honorable Division Bench. Here the petitioner, after joining the service, kindly come page 50. Here the petitioner, after joining the service, completed her training course, DLED. He was the student of DLED into the 2017 or 2019. The course of such training came to an end in 31st July 2019. The petitioner successfully completed the said training qualification as indicated above. Therefore, she is entitled to get the enhanced salary from the date of completion of her course on 31st July 2019, not from the date when the result was published. Now, the reason for this is a qualification is entitled from the last date of the session if a candidate successfully qualifies the training course and her qualification does not commence from the date of publication of the result. Therefore, the petitioner is entitled to get the benefits from the date of completion of DLED course from 31st July 2019. I direct the district inspector of schools to grant petitioner an enhanced salary due to attainment of such training qualification from 31st July 2019. I set aside the decision of the authority granting her benefit attaining qualification from the date of publication of the result. So publication is not a factor from the date of completion of the course. My contention is, now, Lordship, this was an order. I have annexed for the, now, Lordship, subsequently, several writ petition was filed and ultimately, kindly come the Honorable Division Bench order at page 59. Several Lordship, the mandamus appeal was heard analogously regarding the same issue, whether 1 year teachers training course is eligible for getting a category scale. That is page 59. All these appeals involve the common questions of law and facts are taken up together by consent of the parties and dispose of the common order along with the application. The appeals preferred by the concerned district primary school council were heard extensively on 11th February 2021, on which we dispose of the stay application directing the concerned district primary school council to pay a category scale of pay to the writ petitioner for subsequent period and shall continue till the disposal of the appeals without prejudice to the rights and contention of the appeal. Sri Sunil Tudu preferred an appeal, mat number such and such, in view of the denial of such rights to the petitioner by the learned single judge, although he seems to have been similarly circumstances as that of the other petitioners in the batch of appeals preferred by the concerned district primary school council. Mr. Such and such advocate appearing for the concerned district primary school council has submitted that the interim order passed on 11th February 2021 by disposing of the stay application has not considered the notification of 3rd September 2001 issued by the NCT. The order passed by the Joint Secretary, Government of West Bengal, Education Department, Elementary Branch, dated 4th March 2013 is not applicable since the memo issued by the Joint Secretary, Government of West Bengal School Education Department, Law Branch, 19 December 2014 says, unless the teacher concerned obtained the training certificate on and from 31st December 2005, such teachers would not be entitled to a category scale of pay. Mr. Such and such learned advocate appearing for the writ petitioners, respondents, in respect of the appeals filed by the concerned district primary school council, Murshidabad relies upon the interim order dated 11th February 2021. Mr. Learned advocate such and such appearing for the MAT number 107 of 22 has submitted that the detailed interim order passed by us and covered other aspect of the issue raised by the present appellants in other appeals. And it would be clear from the reading of the circulars together with the order passed by the appeal committee of the West Bengal Board of Primary Education that the writ petitioner are entitled the said relief. Mr. Such and such learned advocate in the addition to the said relief, the order passed by the coordinate bench in MAT 1666 of 2015, can number such and such 7th December 2015, in which a decision of the Commission of School Education dated 11th December 2012 expressed the view that writ petitioners in the said proceeding are who are appointed before 3rd September 2001 and obtained PTTI courts in the sessions of 5 and 6 are entitled to get a category scale of pay in terms of the notification dated 26 March 2012, subsequent to 15 June 2012 of the School Education Department. In the instant case, there cannot be any dispute that Prem Kumar Basak and others, mat number such and such, were similarly placed as that the present writ petitioner, they are entitled to the same benefits of a category scale of pay, although the order of the coordinate bench does not decide the issue elaborately, but it appears that even the state of West Bengal considered that since the teachers were appointed before the cutoff date, obtained 1 year PTTI degree in the sessions 5 and 6 would be entitled to get a category scale in terms of the relevant notification as duly communicated by the Commissioner of School Education in its letter dated 11th December 2012, and on the basis of the order of Secondary Education Department 19 December 2014 was not accepted. However, without taking into consideration the aforesaid order, we passed an order on 13 January 2020 FM 804 of 2019 can such and such in respect of the chairman District Primary School Council, in which on the basis of the clarification notification of 4th March 2013, we are of the view the writ petitioner in the said proceeding would be entitled to a category scale of pay. The said order passed in consideration of the notification dated 4th March 2013. However, in the present proceeding, we have heard the learned advocate general earlier on 11th February 2021, where we have elaborately discussed the issue, and the issue which are now sought to be raised were considered by us at the time of passing the interim order, since it was a mere repetition of the argument that was made by the learned advocate general, that when we consider the prayer of interim relief, we are of the view expressed by us at the time of passing the interim order shall hold a good even in the final stage in absence of any other better materials being produced at the time of argument. It is admitted position that the government has accepted the order of the appellate committee, West Bengal Board of Primary Education in similar situation, and the said decision was relied by the coordinate bench such and such. We are extensively referred the said order of the appellate authority in our previous order. In view of the facts, we are confirmed the interim order dated 11th February 2021 and dismiss the appeal preferred by the District Private School Council, Murshidabad. Accordingly, the appeal of MAT such and such dismissed. The appeal of such and such preferred by Sunil Tudu allowed. In view of the disposal of the appeal, the MAT M10722 connection with the application can disposed of in Lordship. This was the order. Now, Lordship, this order, Honorable Division Bench order, has reached to its finality. Now, Lordship, kindly come what was the interim order passed by the Honorable Division Bench. Lordship, the interim order I have annexed in my exceptions. Kindly come my exceptions. What was the interim order has been affirmed by the Honorable Division Bench. Kindly come my exceptions, page 9. Where the learned advocate general appeared. And this order has been accepted. Till date, not even challenged. But I'm not giving the trouble to read the entire order. So kindly come page 14. We have also got it. Second paragraph. We have considered the rival contention of the parties that it is admitted position the writ petitioners were appointed prior to promulgation NCT dated 4th September 2011. It is also admitted position that they were deputed for the said course for academic session 5 and 6. This is very relevant for us, 5 and 6. One of the earlier government notification, namely notification 13th August 2012, as mentioned, the teachers appointed prior to 3rd September 2011 would be governed by the state government norms in relation to the upgradation of their qualification who may not possessing the same as per the requirement of NCT. It further pointed out that the teachers appointed between 3rd September 2001 to 31st December 2005 possessing the academic sessions as per the government norms and completed 1 year of the 2 years teachers training course from the state recognized institutions are not required to enhance their qualification as per note 2. It is subsequent notification dated 4th March 2013. In clause 3, it is stated that the teachers who have attained 1/2 years diploma in elementary education from the state recognized institution and appointed as a teacher on or before 31st December 2005 shall be treated as a trained teacher. The question arises for consideration is whether pursuing the course of academic sessions 5 and 6 by the present petitioner who's entitled them to get a category scale of pay. The appeal committee of the West Bengal Board of Primary Education in a similar situation held that the respondent council was justified in withdrawing the benefits of a category scale of pay from one teacher, namely such and such, who was similar placed as that the writ petitioner Prasanto Kumar such and such also joined service on 2nd July 1999 and was extended similar benefits until he was withdrawn later. The appellate authority in a well-considered decision has observed that such benefits would not be given withdrawn from such and such on relying upon the judgment delivered on coordinate bench MAT is as follows. Now, Lordship, kindly come page 60. We are of the prima facie view that clarificatory of GO number 4 Lordship, the March 2013 in para 3 of the said notification, it is clearly stated that the teachers who had attained 1 year, 2 year diploma in elementary education from the state recognized institution and appointed as a teacher on or before 2005 shall be treated as trained teacher. In view of the clarification, it is clear the teacher who was appointed as an assistant teacher before 31st December 2005 and attained 1 year of the 2 year PTT course from the state recognized institution are eligible to be treated as a trained teacher. In view of the fact, teachers, writ petitioners have received a category scale of pay up to September 2018. We dispose of the stay application by directing the appellants to pay salary a category scale of pay to the writ petitioner for the subsequent period and shall continue to pay till the disposal of the appeal without prejudice to the rights and contention of the appellants. In the event appeal succeed, needless to mention that any payment made in the this is not. Now this order has been affirmed by the subsequent order which I have placed by the Honorable Division. So Lordship, now as on today, Lordship, the 5 and 6 sessions candidate who, Lordship, he completed the sessions within June 2006, but due to different court cases, so I will come later on with the documents. Lordship, for the court cases, the examination could not be held and held in 2011. They are entitled to get a category scale. Lordship, there is no dispute. Now, Lordship, kindly see what is the report. Report is absolutely in violation of the order of the Honorable Division. The division bench order has not been considered. In spite of that, in Sunil Tudu's case, Birbhum District Biological Council was a party. Let's kindly come the report. When the Lordship, the Honorable Division passed order against this chairman, Birbhum District Biological Council, Lordship, they have totally flouted the order of the Honorable Division Bench by filing the instant report. Kindly see that it is clear from the memo dated 4th March 2013 issued by the Joint Secretary Government of West Bengal School Education Department about the criteria of obtaining a category scale of pay in favor of the primary teachers. In para 3, under the above noted memo, such and such, that teachers who have completed 1 year, 2 years diploma in elementary education from the state recognized institution appointed as teacher on or before 31st December 2005 shall be treated as a 10 teacher. Now that the instant case petitioner appointed 91 as an assistant teacher under Bardwan DPSC and the transfer joined on such and such, the petitioner has not attained 1 year of the 2 year diploma in elementary education from state recognized institution on or before 2005. That the petitioner attained 1 year diploma in elementary education after 2005, the result published on 2011. The petitioner passed diploma in elementary education to 2017-2019 session and the result published on 2019, petitioner allowed a category scale from 2019. In the light of the above, petitioner is not entitled to a category scale. Absolutely, Lordship, this affidavit is floutation of the Honorable Division Bench order. The Honorable Division Bench order, relying upon this notification 4th March 2013, said that 5 and 6 candidates are entitled to get a category scale for completion of 1 year PTTI training. Now, Lordship, kindly come to the Lordship, the order of the Lordship, the coordinate bench, kindly come page 67. Here is the Birbhum District Biological Council was the party. And same issue has been raised, Lordship. Herein the issue has been, the District Biological Council has taken a two stand. In this case, page 67, they say no, petitioner entitled to get a category scale in terms of the Honorable Division Bench from 2011, not from 2006. Here in this case said, no, petitioners are entitled to get a category scale from the completion of the training, not from the complete result, because the commission could not conduct the examination due to their internal arrangement. Lordship, this 5 years, Lordship, the petition 5 years delay in conducting the examination, petitioners could not be Lordship, the blame. Kindly come page 67. This order also has not been challenged till date. I am reading, Lordship, from paragraph 2. The issue to be decided herein from which date are petitioner entitled to a category scale of pay. All petitioners are working teachers who entered in the survey DPSC Birbhum without a valid PTT training qualification. They undertook the course to obtain the qualification during their employment. Admittedly, each of the petitioners underwent a one-year PTT course with the sanction of the DPSC at the institute recognized by the West Bengal Board of Primary Education. The DPSC Birbhum represented by such and such has advanced several arguments in support of the contention that petitioner would be entitled to a category scale from only after the last date of examination of the teacher's training course undergone by the petitioners. So, Lordship, herein the chairman has taken the stand that I am entitled to get a category scale from the last date of examination. So, last date of examination as per the examination scheduled in 2011. Reliance is firstly placed by the counsel for the DPSC on the decision of the division bench of this court, Tulsi Boxi versus State of West Bengal and others, that is reported in 2008 for CHA. The proceeding was a public interest litigation. In case of Tulsi Boxi's case, Supra was that since NCT prescribed and recognized only 2 years PTCI course, and institutes concerned where the petitioner undertook the course were not recognized by the NCT, whether the course undergone inter alia by the petitioners constituted a valid PTT or not. In the PIL, it was ultimately held that since the institute and the course were not recognized by the NCT, the courses undergone by the writ petitioners could not be accepted. The institutes were directed to refund the fees paid by the writ petitioners. It also follows as a corollary that the course being only for 1 year were even otherwise not recognized by the NCT. The petitioners appeared to be caught between the devil and the deep sea. They had undergone 1 year course on the basis of the recognition of such institute offering such courses by the BPE, and with the permission of the DPSC, 1 year course was invalid as per the High Court and NCT. The petitioner wasted 1 year of their career and life. The board, DPSC, having realized its error and misleading the teacher's approach, the NCT for a solution. The solution arrived was at that on the time measures inter alia, the petitioner would be allowed to undergo bridge course for 1 further year in addition to 1 year course already undergone by them. The petitioner would then deem to be lawfully qualified. It is only therefore the examination of the 1 year course and 5 or 6 were held in 2011. It is from the day after the last day of the said examination according to DPSC of the petitioners are entitled to a category scale. Therefore, even the DPSC has not taken 1 year bridge course as a condition precedent a category scale of pay to the petitioner. The learned counsel for the writ petitioner referred the circular 4th March 2013 issued by the Joint Secretary School Education Department Elementary Education Branch, from which there could be an interpretation that the actual qualification of PTC and the consequent A category scale was referred to only 1 year course as a recognized by the board. The teachers have now been completed 1 year bridge course, given a category pay scale from the day of completion of the original 1 year PTCI course, that is June 2006, which they join in the institution for the DPSC and West Bengal Board of Primary Education. Mr. Learned Advocate has referred full bench judgment of such and such, which was heard in such and such, along with the several writ petitions such and such, and the circular of Education Department Budget Branch of the Government of West Bengal dated 17th September 84. It was submitted herein that the benefits of higher scale of pay acquiring the highest qualification accrued only from the last date of examination. The law follows across the country, the state as follows. The said principles, however, may not apply in the peculiar facts and circumstances of the case of the writ petitioner. The petitioners believed in and relied upon the board and DPSC undertook 1 year course and legitimately expected to get a category scale after 1 year of June 2006. The board and DPSC are therefore estoppel from going back to their representation that the petitioners were be undergoing a valid training course. The petitioner must be understood to have altered their position irretrievably and have acted upon the same. The said decision of Tulsi Boxi's case must be deemed to have been eclipsed since after the board as a special case allowed the petitioner not only sit in the final examination conducted by the said unrecognized institute but also subsequently undergo 1 year beach course. By the reasons of this argument, the right of petitioners under the circular 4th March 2013, Supra would revive automatically. In effect, the petitioners would be entitled to a category scale of pay upon expiry of 1 year course 5 and 6, which as final examination would be conducted June 2006. The DPSC has itself argued that upon successful completion of examination of 1 year, albeit held after 5 years 2011, the petitioner would be entitled to a category scale subsequently undergoing of 1 year beach course, therefore need not to be counted. And if completed successfully, petitioner therefore cannot be penalized for delay of 5 years in holding the exam for the year 2005 and 6. The legitimate expectation on the part of the petitioners a category scale of pay acquiring June 2006 crystallized and matured promissory estoppel with the subsequent steps taken by the board. Now, also, this was the order that petitioners are entitled to get a category scale from the completion of the training, not from 2011, not only from the 2019. Now, also, in terms of this order, now, also, the several judgments, several orders we have got in presence of the learned advocates for the Birbhum District High School Council. Kindly come page 75 and 77. Effect from June 2006. Kindly come page 75, relevant page 76, paragraph 4. All our assistant teachers, Lordship, 5 and 6 candidate, Lordship already ordered to get a category scale from 2006.
The petition is similarly circumstanced.
Similar. Now, Lordship, kindly come 77 also. Page 4, same order. Now, all these orders till date have not been challenged. What is my son?
Lordship, may I place page 50? My learned senior has placed it. It is the order of one of the single judges of our High Court. May I place the first paragraph, Lordship? Here the petition has joined.
Exception.
No. The repetition only. Repetition page 50, Lordship. 50. At the petitioner after joining, Lordship, of the learned single judge of our High Court, Lordship. Here the petitioner after joining the service completed her training, namely DELED. This is not PTTI. This is DLED course. He was a student for the session 2017-2019. My learned friend's client has also completed 2017-2019 and he is getting a category from 2019. It is an admitted fact, Lordship. Now, Lordship, may I place the order of our division bench?
He has appeared in PTTI exam.
He has appeared in PTTI 2005-06. He has also done training of DLED from 2017-2019. He has done 2 courses.
So if
1
he
year
claims
course training.
the PTTI is a valid course to grant a category scale of
Why he has done 2017-2019 DLED? So that was not valid. Then what the
Second issue, Lordship.
no.
The learned, my learned senior has placed one division bench order. May I place page 63, Lordship? Last three lines, page 63. While disposing of learned division bench, Lordship, last three lines. May I read, Lordship? We are of the view that the view expressed by us at the time of passing the interim order shall hold good even at this final stage in absence of any other better materials. Kindly note, being produced at the time of argument. So maybe the learned division bench was of the view that if any other materials would come out, the order would have been different. Now, Lordship, I will place the 4th March 2013, page 48. The memo of the government of West Bengal.
Page 38.
Page 48, Lordship. 4th March 2013.
Yes.
Last paragraph, Lordship. 3. May I please? Teachers who have attended. The meaning of attend, Lordship, subject to correction. I have gone through the dictionary of the Black also. It is succeeded in achieving. Means the degree had to be achieved, accomplished, gaining something, achieved. This is the description of the dictionary of Black, Lordship. The word attend. Attend 1 or 2 years diploma in elementary education for the state recognized institution, appointed as a teacher on or before. That is not disputed. He is appointed before in 1991. So he has to complete the 1 year course before 2005. But the petitioner has completed the training as per his documents he has annexed in page 40, Lordship, on 17 June 2006. This is his completion certificate. I'm not going into the examination and anything. He has completed his training at page 40, Lordship, 17 June 2006. Page 40, Lordship, 17 June 2006, he has completed his training. Not the examination, Lordship. So the word attend have to be looked into, Lordship. This is my respectful submission, and the same thing I have relied on my report also. That page point number 3, 4 and 5, that I am relying on the notification of the state government 4th March 2013, Lordship. Paragraph 3. This is my respectful submission, Lordship. In any event, other courts has passed orders. Lordship can take a different view or Lordship can go with the same. It is up to the Lordship, your Lordship to
There are
decide.
two aspects of it.
Lordship.
A person while in service in the year 2005, prior to 31st December 2005, completing PTTE course.
Lordship.
And claiming his A category scale of pay with effect from June 2006.
Lordship.
When it was supposed to complete but not completed.
Lordship.
The single bench and has considered several orders in the order that he has indicated.
No,
of Justice
it was completed, Lordship. 17 June, he has completed the training.
I come to that.
Lordship.
Come to page 67. This is a similarly circumstances as of the petitioner. They were also working as assistant teachers and they have completed PTTE qualification.
Lordship.
There also the similar issue arose.
Lordship.
That this is not as per NCTE guidelines, this is not a recognized.
Lordship.
And the court, after due consideration and also taking into consideration the orders passed in the coordinate bench, you come to page 72. It has quoted several orders of this court,
Lordship,
and thereafter it has granted.
Several orders, but I am into the order passed by the division bench, that aspect, that any other materials. I am
Now,
only
if
into
he
the
gets
word
a
attain.
higher degree and rely on another degree that supports his case, now he will be deprived of that, since the order has been consistently passed by this court. Yesterday, an order was placed in which it said that from the conclusion of the examination. So I asked them to produce that.
I am into the word attained, whether that completion has been done within that as per the notification, Lordship. This is the small point I have raised.
May I read again this clause 3? Teachers who have attained 1 year diploma in elementary education from the state recognized institution. So 1 year Now, Lordship, and there is a conjunctive. Appointed as a teacher on or before 31st December 2005. My appointment ought to have been 31st December 2005, not the training.
Appointment is of 2000 before 2005. That is not disputed. That is not disputed.
2005, not the
He has
training.
appointed.
That is
Teachers,
the Honorable Division Bench order. That's why, Lordship, the 1 year training has been allowed to a category scale.
may I read once again, Lordship? Teachers who have attained 1 year / 2 years diploma in elementary education from a state recognized institution. What does that mean? It is a training. He has to attain 1 year, 2 year diploma in elementary education. These are two aspects. Attained means completion. This is my respectful submission, Lordship.
Then I am not entitled to, Lordship, because within 2005 no training is there. Then I am not entitled to a category scale. Why the bridge course? They are taking the bridge course. Even, Lordship, 2000.
My land, the petitioner was in confusion. That's why he has done the DLED course of 2017-2019. Why he has done that? It was not required.
Interpreted in such a manner that I have not completed the training by 31st December 2005. I have completed the training after 31st. Then, Lordship, I am not entitled to a category scale. Not at all. Lordship, from the till appointment to till my retirement, I am not entitled to a category scale. But they have given their category scale. Now, in one case, they are saying you are entitled to a category scale since 2011, from the last date of examination. Now they are saying, no, after completion of the bridge course. Lordship, this interpretation already has been given by the Honorable Division Bench that the appointment has to be made by 31st December 2005.
Tell me one thing, that whether this order passed in WPA 10630 of 2024, where the similar issue failed for consideration, has been appealed against or not?
Lordship, 10630. No, till date, Lordship, I am the petitioner. I have appeared in the petition. No appeal. No. I am taking the responsibility because I appeared in this. And Chairman Birbhum District Fiscal Council is the party.
And subsequent thereto, several orders have been passed by the similar bench.
Consequently, rely upon this same order, same.
Kindly record my submission, whatever order Lordship wants to pass. And my respectful submission is Lordship can decide the issue afresh if some new issues are there, because division bench has already noted that.
Asun. The petitioner in the present writ petition, the petitioner seeks direction upon respond numbers 3, 4, 5, and 6 to extend a category scale of pay to the petitioners from the date of completion of the sessions of teachers training with effect from 19 June 2006 together with interest. The petitioners, how many petitioners are there?
Only one.
The petitioner is an assistant teacher of Dishergad AC Primary School. Joined, no? He joined in Bardhaman.
Yes.
Presently in Birbhum.
Present.
Joined in Dishergad AC Primary School at Dishergad under Kulti Circle in the district of Bardhaman as an untrained teacher on 5th December 1991. Subsequent thereto, the petitioner was transferred to which school?
Kuitha, Kuitha, Kuitha Primary School.
Kuitha Primary School. এখানেই হবে কোথাও Kuitha Primary School, post Sahapur district, Birbhum. The petitioner completed the primary teachers training course for the session 2005-2006 in the successfully completed, the results of which were declared on 14th July 2011. The petitioner has been granted A category scale of pay from 1st July 2019. Mr. Mukherjee, dates are correct? 1st July 2019. The petitioner claims that the A category scale of pay ought to have been granted to the petitioner from the date of completion of the course, that is June 2006. Hence this writ petition. Mr. Prosenjit Mukherjee, learned advocate, appearing for the petitioner, submits that as per the notification of the issued by the District Primary School Council, Birbhum, the petitioner, page 34, what is the date of this document? 16th July 2005. The petitioner registered himself for completing the course under the course, namely primary teachers training for the session 2005-2006. A subsequent, where is the notification dated 4th March?
48, page 40.
By a subsequent notification dated 4th March 2013, it was notified that the teachers who have attained 1 year/2 years diploma in elementary education from state recognized institutions and appointed as a teacher on or before 31st December 2005 shall be treated as a trained candidate. The Honorable Division Bench in Sunil Tudu versus State of West Bengal and others, MAT 107 of 2022, as well as along with other appeals, in similar circumstances have held that the petitioners are entitled to A category scale of pay. The date from which the entitlement of the petitioners of A category scale of pay also fail for consideration in before a coordinate bench of this court in WPA, Swapon Kumar Das versus State of West Bengal along with other writ petitions. A WPA হচ্ছে 10630 of 2024. Wherein effect has been given from June 2006. He also indicates that consistently in respect of the other petitioners, other candidates, this court has passed orders subsequent thereto, entitling the petitioners from June 2006 to A category scale of pay. There is no appeal against the orders passed by the learned single judge in respect of similarly circumstanced petitioners, as aforesaid. In light of his aforesaid above submissions, he prays that the petitioner, who is also similarly circumstanced, be extended the benefit of A category scale of pay with effect from June 2006. On the you are for the state?
For the state.
What is your submission, sir?
I have already submitted report, my lord. Will kindly come to paragraph 3, my lord. 3 and 4, my lord.
Mr. Kaushik Chaudhary, learned advocate appearing for DPSC Birbhum, referring to the notification dated 4th March 2013, submits that the word inverted comma attained means one who has successfully completed the course. Undisputedly, the petitioners did not complete such course of diploma in elementary education from state recognized institution prior to 31st December 2005. And as such, they are not entitled to A category scale of pay with effect from June 2006. The petitioner who has also completed his DLED course for the session 2017-2019 has been granted A category scale of pay with effect from completion, successful, with effect from the date of the results, publication of the results. Mr. So-and-so, learned advocate appearing for the state, submits that since the petitioner on the date of on 31st December 2005 did not complete diploma in elementary education, he is not entitled to such relief as prayed for.
At the time of his joining, my lord.
How joining? The cutoff date is 31st December 2005. You have stated that he will not be entitled from such date. Why then date of joining? Why the date of joining is coming? There is no question on date of joining. 31st December 2005 is the cutoff. The writ petition is not from the date of joining, I suppose. Are you claiming date of joining or date of then? What is the question of date of joining?
And in 1991, there was no provision for a category scheme.
But you have in your, he is correct. In prayer B, you have stated date of joining.
No, other pay benefits.
Then what is your prayer is completion?
Date of joining to the concerned primary school after completion of the session.
A was correct. Again, B, the interpretation changes.
No, Lordship, here, Lordship, petition is a retired.
Eightai rakun. Date of completion of the session.
Yes. Yes.
Aja. The entitlement, sorry, having considered the submissions of the learned advocates for the respective parties, the issue which falls for consideration is whether the petitioner is entitled to a category scale of pay from the date of completion of the training, that is June 2006. So far as the entitlement of a category scale of pay of the petition is concerned, the same is no more res integra in view of the decision of the Honorable Division Bench passed in Sunil Tudu Supra in Mat 107 of 2022. The second aspect which falls for consideration is from which date the petitioner will be entitled to a category scale of pay. This has also been decided in WPA 10630 of 2024, wherein in case of similarly circumstanced petitioners, this court has granted a category scale of pay, has observed as follows. Para 25 to quote. A coordinate bench, the state coordinate bench subsequently also passed orders in WPA 4381 of 2024 as well as WPA 4378 of 2024, granting a category scale of pay with effect from June 2006. Relying on the decision of the Honorable Division Bench in Mat 10 in Sunil Tudu Supra. Therefore, in line with the aforesaid decisions, the petitioner is entitled to, who has completed the course in the year 2006, June 2006, is entitled to a category scale of pay with effect from June 2006. Accordingly, who is to grant the A category scale of pay? Which authority?
What's the phone number? Chairman is the
BPSC given.
BPSC forward.
Is entitled to grant of A category হলো তো?
PSC forward.
State দেবে
State দেবে।
DPSC কোনো
The concerned authorities are directed to
Commissioner of School Education.
take necessary steps in view of the observations made herein above. With the aforesaid observation, the writ petition being number such and such stands disposed of.
Lordship, instead of concerned respondent, kindly mention 3, 4, 5, and 6.
The DPSC is nowhere related, Lordship. The state will pay, Lordship. Grateful.
Kindly mention the date, Lordship, within a period to complete.
Within a period of 2 months from date of communication of this order.
Grateful, Lordship.
কিছুই দেয় না এটা না ওই সাপ্লিমেন্টারি অ্যাফিডেভিট মানে এক্সেপশনটা আজকে ফাইল করে ইউ আর ফাইলিং এক্সেপশন টুডে না
The report file.
ওটা নোট করুন
20.
But I am for the petition. This is in respect of my lord,
this is
but overdrawn in pay. But on the last occasion, your lordship directed me to produce the my lord copy of the my lord
order.
But I have order of the DPS.
When did he retire?
Retired from service on my lord 30th April 2021.
21.
My lord. The overdrawn amount was my lord, deposited by challan by the petitioner
On
My lord,
on
C is
20th
untrained.
January 2021.
My lord, C is untrained and C is overdrawn. 1/8/19 2019 and এখানে 31st 12 2020.
enhanced method with effect. No, we are not. As per the chairman in 2020. Has he retired from service on?
Retired from service on 30th April 2021.
2021.
Yeah.
My lord.
30th April.
My lord.
Refund.
It was directed within 1 year. Topic.
It's untrained.
On-trend will not get the refund.
No.
Why? Where is that? Where have you written?
Paragraph, yes, paragraph 4.
4.
Italian 1 and 2.
Oh.
Is overdraw.
You have the copy of the
Yes.
decision of Rafiq Masi?
But I am handing over. I am relying on paragraph 13, 16, and 18.
Not impermissible. Group D. The next statement is made for a period of আসুন আসুন আচ্ছা এসে বলুন। আপনি থাকবেন পরে? Report filed by the state is taken on record. Report filed by the state furnished by District Inspector of Schools, Primary Education, Paschim Mednipur, dated 12th February 2026, is taken on record. By the present writ petition, the petitioner seeks for refund of
30,576.
the. When did you deposit that amount, or this was
I have deposited the amount on my lord
refund of overdrawn amount of rupees
20th January 2020.
30,576 deposited before the respondent authorities together with interest. The petitioner contains that she was an assistant teacher of Dhangori Primary School, village Dhangori, post Markunda, district Paschim Mednipur. The petitioner retired from service on superannuation on 30th April 2021. The petitioner was directed by the District Inspector of Schools PE Paschim Mednipur to deposit the overdrawn amount of salary of rupees 30,576 in order to process the pension papers. The petitioner duly deposited the aforesaid amount to the Treasury Officer Kharagpur on 20th January 2021. Upon deposit of the same, the pension payment order has been issued to the petitioner. The direction of the respondent authorities for deposit of the overdrawn amount is impermissible in law. Hence this writ petition. Mr. So and so, learned advocate appearing for the petitioner, submits that the petitioner was asked to deposit the amount of overdrawn salary within a period of 1 year of her retirement, which is impermissible in law. To buttress his contention, he relies on the decision of Honorable Supreme Court passed in State of Punjab and others versus Rafiq Masi, Whitewasher and others, reported in 2015, Volume 4, SCC 334. On the contrary, Mr. Moha Datta Bishwas, learned advocate for the state respondents, submits that the petitioner was an untrained teacher. However, the grade pay has been wrongly calculated in respect of the petitioner, which has resulted in disbursement of excess money, excess salary to the petitioner because of wrong fixation. Therefore, the petitioner cannot claim refund of the overdrawn salary. She seeks for dismissal of the writ petition. After Rafiq Masi ji case overdrawn থাকে, the only issue which falls for consideration is whether the respondent authorities were justified in directing the petitioner to deposit the overdrawn salary amount. In order to examine the aforesaid issue, it would be apposite to reproduce the observation of Honorable Supreme Court in Rafiq Masi Supra as hereunder, para 18. It is not in dispute that the recovery of the aforesaid amount has been made within a period of 1 year of retirement, which as per the proposition laid down by Honorable Supreme Court in Rafiq Masi Supra is impermissible in law. Accordingly, respond number baki paragraph same will refund this such and such amount within a period of দেখে নেবেন এটা period of 12 weeks or 8 weeks whatever, together with interest at the rate of 8% per annum from the date of deposit till the date of actual payment with the aforesaid disposed of.
Grateful.
Grateful, my lord.
Thank you. No.
Item number 393.
I am for the state, my lord. May I please your lordship, my lord. I beg to appear on earlier occasion, your lordship directed me to file the report regarding the, my lord, the order passed by the Honorable Justice Arijit Banerjee and the Honorable Justice Tapobrata Chakraborty. I have the report, my lord, and annex the petition of the authorities, my lord, the authority rejected their application.
Rejected.
So I am submitting, my lord, that the authority would same guideline, your lordship can see. Two orders are there, my lord. One order passed by the district inspector of South 24 Parganas. The next is of the order passed by his lordship, the Honorable Justice Tapobrata Chakraborty, and the next page is, my lord, last page, my lord, Justice Arijit Banerjee, dated 13/9/2027. Two decision I have annexed, my lord. So, my lord, my distribution subdivision is, my lord, the only 1/3 share he is entitled to get. Other two share which was seized as per rules. Baba. আমরা? I have already served a copy of the report, madam, to my learned friend.
Should we do?
Yes.
But may kindly have the reasoned order, my lord, the last reasoned order, my lord, in which, my lord, they have mechanically considered the notifications, my lord, without even a whisper, my lord, to the opinion that has been expressed, my lord, in the judgment, my lord, directing them to pass a reasoned order. The lordship sees, my lord, nowhere in this reasoned order, my lord, there is a reference to the observations, my lord, which has been there in the reasoned order, in the order passed by this honorable court, directing them to pass this reasoned order. My lord, good, bad, indifference, my lord, this reasoned order, my lord, I could not have challenged, my lord. But I can only go by the decision that has been rendered by this honorable court, my lord. And in that decision, my lord, there in unequivocal terms, my lord, your lordship has held, my lord, that your lordship is in agreement with the notification being applicable, my lord. That's number one. Number two, my lord, as I was pointing out on the last occasion, my lord, that the same provisions, my lord, parameteria exist in different jurisdictions across our country, my lord, and different high courts had the occasion, my lord, to consider the import of this particular clause, my lord. And in my respectful submission, my lord, the division benches, my lord. Your lordship kindly sees the last judgment that I placed of the Patna High Court, my lord. Had the occasion, the honorable division bench of the Patna High Court had the occasion to deal with this, my lord. And it has been specifically stated, my lord, that her share, the meaning of her share will imply that, my lord, the widow who dies, her with respect to her, that will cease. And it cannot, by any stretch of imagination, can be implied to mean that the government will be unjustly enriched by the entitlement of the deceased, my lord, husband. Another judgment, if your lordship permit me, my lord, of the Punjab and Haryana High Court, my lord, it has been passed. Review. It has been passed, my lord, in a review petition, my lord, based on a honorable division bench judgment, my lord. This dismissal of the petition of the petitioner was, the dismissal order was recalled, my lord. And based on the observation, my lord, the petitioner therein, my lord, has been granted 100% of family pension. If your lordship kindly sees the observations of the honorable division bench as noted in this judgment, my lord, if your lordship kindly permit me to hand up to your lordship. Reported audit. Application 847 of 2025. This has been very recently passed on 23rd of December 2025. Kindly see.
Lord, may kindly seize, my lord, the facts of the case, my lord. But kindly takes, my lord, main case, paragraph 1 at page 3, my lord. The husband died in harness in 2014, my lord. The first wife died in 1997, my lord. Thereafter, my lord, the solemnized marriage in 1999, my lord. Although, my lord, the facts may be facts may not be material, my lord, but what would be of substance, my lord, if your lordship kindly sees the observation recorded at paragraph 4, my lord, of the judgment, my lord, which start at page 5, my lord. Lord, may I place it? Paragraph page 5, my lord. In bold is given, my lord. I am placing it for your lordship, my lord. This court has already interpreted the said note 1 below, Rule 6.174 of the Punjab Civil Services Rule Volume 2, while reading such and such on such and such titled as such and such of this court, while deciding Harpal Court's case, Supra has held that the share of the legal heirs cannot cease. Kindly mark, my lord, cannot cease, as the government is under obligation to release 100% of the family pension. And if a legal heir becomes ineligible, her share cannot cease, my lord, and cannot be retained by the government. Against the said decision, the state of Punjab preferred LPA, which is, my lord, later patent appeal number such and such, titled as such and such. The said LPA was decided by the division bench on such and such, and the order passed by the learned single judge in Harpal Singh's case, Supra, was upheld. My lord, the state preferred an appeal against the decision of the honorable single bench, my lord, with regard to the observation that has been quoted, my lord, and the LPA was also dismissed, my lord. My lord, that is one. Now, my lord, kindly please, my lord, page, my lord, 7, paragraph, page 7, my lord, paragraph 12.
Yes.
My lord, kindly see page 7, my lord, paragraph 12, my lord.
Seen.
It. Kindly see, my lord, next page, page 8, my lord. There is another paragraph 12, my lord, which is golden part, my lord. Kindly see, if there is only one legal heir, my lord, who is eligible for the grant of family pension, my lord, she will be entitled for full, my lord. 100% of family pension, and well, kindly mark, no portion of the same can be retained by the government by taking shelter behind note 1 and 2 of rule 6.174 of the Punjab Civil Service Rules Volume 2, which is, my lord, the rule that is parameteria with the rule that we are dealing with, my lord, which is paragraph 26 of the scheme of 1981, my lord. Now, my lord, in view of which, my lord, kindly sees the page 9, paragraph 5, my lord, the last sentence, any interpretation. The fourth line from the bottom, my lord, paragraph, page 9, paragraph 5, my lord, last 4 lines of the bottom. Any interpretation. Any interpretation of rule 6.17 or it notes that leads to the state retaining a portion of the family pension would be contrary to the very purpose and object of the family pension scheme, which is to provide financial security to the family of the deceased employee. My lord, kindly text, my lord, next page, paragraph 7, my lord. As such, my lord, as such, if the interpretation given by the respondent is accepted, it would lead to the absurd and unjust consequence of the state misappropriating a part of the family pension meant for the deceased family, which is contrary to the spirit and purpose of the family pension. Well, kindly take the next paragraph also, my lord, in the same breath. The action of the respondents in restricting the petitioner's family pension to 50% by invoking rule note 1 to rule 6.17 is manifestly erroneous, arbitrary, and unsustainable in law. The state can, kindly marks, my lord, the state cannot usurp or withhold a portion of it, and the petitioner only remains. I think, my lord, it would be when the petitioner, my lord, not and, but be that as it may, my lord, and the petitioner only remains the eligible person to enter. Oh, no, and, my lord, and the petitioner only remains the eligible person to entirety of the pension, my lord. Yeah, this is one of the judgment, my lord. Now, my lord, kindly consider, my lord, other different jurisdictions, my lord. This is another এটা আমি আগের দিন কোট করেছি this judgment I could not place the facts correctly my lord kindly have it my lord
Which judgment is
my lord 2015 my lord
Earlier occasion, my lord.
yes my lord, I did not place the facts correctly my lord no lordship returned that judgment
Patna?
but no my lord Punjab and Haryana now my lord this is a case my lord your lordship will recall my lord where the husband superannuated my lord in 1991 my lord which your lordship will be pleased to find my lord at paragraph 4 my lord page my lord 2 paragraph 4 my lord lordship will find that he attained superannuation in the year 1991 now my lord the first wife the husband died my lord kindly marks 1993 1993 the husband dies my lord that your lordship will be pleased to find my lord at paragraph 11 paragraph 11 my lord the death of the husband is recorded as in the year 1993 my lord kindly see my lord
Yes.
now my lord the first wife now the suit was filed in that paragraph itself my lord 2003 the suit was filed for the pension my lord by the second wife my lord in 2003 same paragraph now the first wife dies my lord during the pendency of the suit in the year 2005 so my lord at the time of death both the wives of the petition of the husband my lord was alive. Now, my lord, if your lordship sees several judgments has been referred to, my lord, and the conclusion that has been drawn up, my lord, in this, my lord, kindly see paragraph 22, my lord. I think the last paragraph, my lord, paragraph 22.
Paragraph 22,
my lord, last paragraph. Applying the ratio of the above mentioned judgments, the present, oh my lord, before I take your lordship to this paragraph, I'll just indicate, my lord, the learned trial court, my lord, allowed the suit of the second wife by granting her 50% of the pension. The appeal, first appeal preferred by the first appeal that was preferred, my lord. I am not remembering who preferred. Maybe the state preferred the first appeal. The first appellate court, my lord, reversed it, dismissed the case of the petitioner there in the second wife. Second wife prefers, my lord, the second appeal before the Honorable High Court, my lord. Now, my lord, kindly see what is the judgment that has been passed. Applying the ratio of the above mentioned judgments, the present appeal is allowed, and the judgment and decree dated such and such passed by the additional district judge Sonipat is set aside. So the first appellate decree was set aside, my lord, and the judgment decree dated such and such passed by the additional civil judge senior division Gohana is modified. Kindly see, my lord, the first trial court granted her only 50%, my lord, because she was one of the wives. Kindly see, was in the second appeal it was modified to the extent that the appellant is entitled to the complete family pension, my lord, with effect from the death of Jallo. Jallo was, my lord, the first wife. So from the death of the first wife, my lord, the Honorable High Court, my lord, in this case, my lord, allowed the second wife to have the full family pension, my lord, notwithstanding that there is a clause of 6.17 which is parameteria, my lord, toward paragraph 26 of the 1981 scheme.
But that note was not considered in this case.
Yes, my lord, it was considered, my lord.
Paragraph?
Kindly see the judgment itself, my lord. Kindly see paragraph 11 itself, my lord. Kindly see paragraph 9, paragraph 8, my lord. Reference was made to para 6.17 subrule 4 note 1. Chapter 6 under the family pension.
Yes, yes.
It was considered. Considering that she was granted 50% by the trial court, dismissed by the first appellate court. Again, the lower learned trial court judgment was affirmed with modification and not 50%. She will be entitled to 100%. My lord, on similar lines, my lord, I have a judgment of the Madras High Court, which although did not have any note or rule to that effect, my lord, but there was a direction by the executive to pay 50% during the.
But we are concerned with that note. If there is a existing
no
that is not there, then don't place.
Right, man. Now, my lord.
So far as Punjab and Patna is concerned, there is a similar language. There is a scheme of the government.
Another thing, my lord, is the
Honorable Supreme Court Judgment 2026 that has placed, that was placed with regard to how a social welfare legislation is to be interpreted, my lord. Kindly consider that judgment, my lord, paragraph 23, my lord.
Kanchana Rai.
My lord, Kanchana Rai, yes, my lord, biography, my lord. 23, my lord, kindly. 20. Yeah, 23. 23, my lord. At page, my lord, 10, my lord. Remain less.
Yes.
Even otherwise, any such restrictive interpretation would fail the test of constitutional validity under Article 14 of the Constitution. The classification sought to be made between the widowed daughter-in-law based solely on the timing of the husband's death, namely A, those whose husband died during the lifetime of the father-in-law, and B, those whose husband died after him, is manifestly unreasonable and arbitrary. Such a classification bears no rational nexus with the object and purpose of the act, which is to secure maintenance to the dependents who are unable to maintain themselves. In both the situations, the women are similarly situated so far as the object of the act is concerned, having suffered widowhood, being without spousal support, and facing comparable financial vulnerability. Denial of maintenance to one category based on a fortuitous circumstance beyond their control is manifestly arbitrary and violative of the guarantee of equality under law under Article 14 of the Constitution. Well, with this backdrop, my lord, may I just give a hypothetical situation before your lordships, my lord, which will also make it very clear before your lordships, my lord, how a literal interpretation of that particular clause will cause an absurd result, my lord, if I say so. Lord, kindly consider there is one minor child born out of the first wife who predeceased the husband, and there are two surviving wives. Now, my lord, see, the husband dies, survived by two wives, two widows, my lord. So, as per we allow the literal interpretation, the minor child will not get anything.
Why?
If your lordship sees the clause, my lord, once again, minor child will not get anything. Well, kindly sees, if your lordship sees, takes the my lord.
Cause
Not 20 rule. It has been stated as rule 26, my lord, it has, but it will be subject to correction. Paragraph 26 note. My lord, lordship will find it at page 28. In their recent order, my lord.
yes.
I'm taking it, my lord. Where an employee is survived by more than one widow. So, my lord, the hypothetical situation is that there are two widows. The family pension shall be paid to them in equal shares. So, the two widows will be distributed equally, 50-50. Minor child till now not there. On the death of widow, now as on date the husband is dying, there is no widow. Her mother is not alive. The minor's mother has died before the husband. So, on the death of widow who is alive, obviously because the first sentence says that the employee survived by more than one widow. On the death of the widow, her share of the pension shall become payable to her eligible minor child. So whose pension will, whose part of the pension? Someone who is alive, a widow who is alive. If at the time of death a widow leaves no eligible minor child, the payment of her share of the pension shall cease. So, my lord, who is this wife? Because if your lordship read it literally, the first sentence has to be read as it is. So, he survived. The widow has to survive the husband. Otherwise, if your lordship do not accept this interpretation, then my case will be easily interpreted, my lord. But your lordship is concerned on the time of death of the husband. So, on the time of death of the husband, if he is survived by more than one widow, my lord, then the rule says literal interpretation. Then the whole of the pension will be apportioned between the surviving widows. If that be so, my lord, the minor child who is born out of the first widow who has predeceased the husband, my lord, will not get anything as per the literal interpretation. So, if this interpretation is taken to its logical conclusion, so after these two widows dies without leaving any minor child, so what will happen to the only sole minor child of the deceased employee, my lord? He, despite being eligible as a person who is eligible to get under the family rules, my lord, but this because of this rule, he will not get anything. So, my lord, this is also, my lord,
Okay.
the absurdity of the literal interpretation. Yes.
Okay. your case, now there is no minor child.
No, no. No.
So your claim is that the 100% will go to the petitioner.
Well, that is one, and another thing I forgot to submit, my lord, that during the meantime they have deducted money as a recovery, my lord. My lordship knows, my lord, Rafiq Masi, my lord, is there, my lord, in which it is not permissible. My lord may kindly take care of that also, my lord. That they have not returned, my lord, money. They said that we have not done. The reason order says
But if that is not brought on record, that it
there
is
is record, my lord, on record. Kindly see the reason order, my lord. Kindly see the reason order.
It will be from which date?
My lord, that is also there. Kindly see, my lord, the order passed by your lordship on the previous occasion. It records everything, my lord. But that is at page, my lord, 21 onwards, my lord. Well, paragraph 5. Although the dates are not there, my lord, it has been recorded, my lord. The respondent stopped payment of her pension and started recovering the amount from the share of the family pension of the petitioner.
This fact is correct.
Yes, ma'am.
So her entitlement is from which date?
The day when the first wife died within 10 days of her husband's death, my lord. Second wife died sometime in the year 2017. So, my lord, petitioner is claiming her full family pension from the year 2017 to be exact, my lord.
14
9,
September,
2007.
following the date of death of the second wife.
Yes.
By the present writ petition, the petitioner seeks for direction upon the respondent authorities. Direction Ricardo. Petitioner seeks for setting aside / quashing off and or withdrawal of the impugned order dated 9 December 2025, Annexure P5 passed by
Respondent number 5, my lord.
Respondent number 5, District Inspector of Schools, Primary Education, Malda. The petitioner contains that her husband was an assistant teacher of Kola Junior Basic School under Horishchandrapur 1 Circle, Malda. The petitioner's husband retired from service on superannuation on 1st January 1992. And he expired on 30th July 2003. At the time of death, the husband of the petitioner was survived by 3 wives. The family pension, what has been recorded in the earlier writ petition, that fact is stated over here. The family pension was released in favor of all the surviving 3 wives in equal shares. Subsequent thereto, the first wife died on 9th August 2003 and the second wife died on 13th September 2017. Naamta note করুন তো. First wife, what is the name of the first wife?
Name of the first wife?
Yes.
There are 3. Paragraph 3. There are 3. Anwara Khatun.
Anwara Khatun. First wife Anwara Khatun, second is Afroja Khatun. None of the first and the second wife left behind any minor child. Upon demise of the second wife, the daughter of the present petitioner made a representation.
My lord. The daughter
where-
of the second wife.
Daughter of the second wife made a representation seeking payment of share of family pension, which was released in favor of her mother. After demise of the second wife, the entire family pension was initially released in favor of the present petitioner. However, subsequent thereto, such payment has been discontinued and the petitioner was directed to refund the share of the family pension of the second wife. Since the petitioner did not refund the amount, the respondent authority stopped her pension and started the process of recovering the payment already made. The petitioner made a representation requesting the concerned respondent not to deduct any amount from the share of the family pension. What happened to that? That was also turned down or not considered?
No, this was not considered. The
Since the prayer of the petitioner was not considered, the petitioner approached this court in WPA 9896 of 2025.
17428 of 2023.
First one.
First one.
Which is that paragraph?
My lord, paragraph page 23, my lord, paragraph 6. The order of that.
Okay. Paragraph 6.
Paragraph of yes, my lord. Paragraph 6
The
of
petitioner filed a writ petition being WPA 17428 of 2023, which was disposed of by a coordinate bench of this court on 21st August 2024, directing the concerned respondents to consider the said representation and take a reasoned decision thereon. Para. Pursuant thereto, a reasoned order was passed by the respondent authorities on 8 April 2025, holding that the present petitioner is not eligible to receive the pension of other two wives after their demise. The petitioner again filed a writ petition aggrieved by such decision being WPA 9896 of 2025. The aforesaid writ petition was disposed of Where is the direction?
Page, paragraph 14.
17 is the direction. Page 25.
No, 20. I bow down, my lord. Yes, my lord. Sorry.
17. 17 quote করবে না?
Page 25, para 17.
Para. Again, by a reasoned order dated 9th December 2025, the prayer of the petitioner was turned down, holding that she is not eligible for the share of other two wives after their demise. Hence this writ petition. Mr. Tanmoy Chattopadhyay, learned advocate appearing for the petitioner, submits at the very outset that the impugned order has been passed without following the directions that were passed in the earlier litigation being WPA 9896 of 2025. 9896 of 2025. The Decisions of this court in WP number 10717 within bracket W of 2017, Sahe Banu Bibi versus State of West Bengal, and এটাকে আগে দেবেন পুলজনটা, and WP 5822 within bracket W of 2009, Fuljan Bibi versus State of West Bengal, has not been taken into consideration, where the Honorable Court has directed the respondent authorities for consideration of the payer of the petitioner therein by taking into account the notification being number 54 capital F within bracket pen dated 13 January 1997. Such notification has not been taken into consideration in the case of the petitioner, holding that it applies to the West Bengal state government employees only, whose service are guided by West Bengal Services Death Cum Retirement Benefit Rules 1971, and does not apply to the case of the petitioner, who is squarely guided by the West Bengal recognized non-government educational institution employees death cum retirement benefit scheme 1981. He also indicates that the prayer of the petitioner has also been turned down, quoting Rule 26, quoting the note of Rule 26. Relying on the decision of the Patna High Court, reported passed in a message Bhagwani Devi versus State of Bihar and others, reported in 2015 SCC Online Patna 9286. He submits that in a similar scheme having the similar note, the court has taken consideration of the same and observed that though the word has been used that upon the demise of the widow and there being no eligible minor child, the payment of her share of pension will cease, but that cannot be interpreted that the family pension payable by the state would stand reduced or the liability to make payment of family pension by the state would cease. For the reason that the right to receive full family pension is earned by the employee for his dependents as a matter of his employment. Buttress his contention, he also relies on the decision of Punjab and Haryana High Court passed in 2015 SCC Online P&H 10444, Premvati versus State of Haryana and others, Vidyavati versus Punjab State Power Corporation Limited and others. Which is the case number?
RACW 4.
RA bracket A, RACW 487-2025. The upper then report filed by the state is taken on record. One is by District Inspector of Schools, Primary Education, Malda, 16 February 2026. He seeks for, আচ্ছা ওপরে না ওনার সাবমিশনটা কনক্লুড করো যে he seeks for appropriate direction for release of the entire family pension in favor of the petitioner. And also for, you have refunded certain amount.
No, they have taken away money. I have not refunded anything.
No, they have deducted the amount.
They have deducted the
And also for a refund of the amount which has been deducted from the share of the petitioner towards that was paid towards the share of the other two wives earlier. On the contrary, Mr. Biplav Guho, learned advocate appearing for the state, submits that the rules of 1971 and the notification number 54 capital F pen dated 13 January 1997 does not apply to the petitioner. The case of the petitioner is guided by scheme of DCRB scheme of 1981, and the rule 26 clearly records that the payment of share of the deceased widow shall cease upon her death. In such event, the petitioner, being the third living wife, is only eligible to 1/3 share the family pension and not more than that. Referring to the report of the District Inspector of Schools dated 16 February 2026, he submits that the earlier orders passed in Sahebanu Bibi Supra and Puljan Bibi Supra, which was directed for consideration, has been rejected by the department on the similar grounds. In light of his aforesaid submissions, that he praised that the petitioner cannot claim for the entire family pension. Mr. Prasad is here.
He engaged with court number 11, Your Lordship.
Learned advocate for DPSC Malda also submits in the similar fashion and indicates that, as per Rule 45 of DCRB Rules 1981, the rules of 1971 shall apply mutatis mutandis, subject to the approval of the state government. As on date, there is no such notification approving applications of Rule 1971. The same cannot be applied in case of the petitioners who are guided by DCRB scheme of 1981. Upon hearing the learned advocates for respective parties, the only issue calls for consideration is whether the petitioner, being the third wife of the deceased employee, is entitled to entire share of the family pension. To examine the aforesaid aspect, the prayer of the petitioner, which was directed in the earlier writ petition to be considered, has been turned down by the impugned order on two grounds. Firstly, that the notification VD number 54F pen dated 13 January 1997 does not apply to the case of the petitioner who are guided by DCRB scheme of 1981. And secondly, note of Rule 26. This is of DCRB 81 of DCRB 1981 makes the petitioner ineligible for the share of other two wives. In order to examine the issues as noted herein above, it would be apposite to reproduce Rule 26 note as hereunder. It 28, page 28. The issues as raised in the present writ petition is precisely relevant with regard to Rule 26 as noted herein above. Learned advocate for the state has emphasized upon the expression on the last part of the note, the payment, inverted comma, the payment of the share of her share of the pension will cease, which means that the share of the deceased wife will cease. It is placed on record that a family pension is not a bounty or gratuitous payment. The family pension is paid to the surviving dependents to support their livelihood. From bare reading of the aforesaid note, it would be evident that what is conveyed is that the share of the deceased wife goes to the beneficiaries. However, that does not mean that the family pension payable by the state would stand reduced or the liability to make payment of family pension by the state would be reduced. Upon discharging duties, a retired employee or his dependent are granted pension or family pension as the case may be. This could find substance in submission of Mr. Chattopadhyay relying on the decision of Bhagwani Devi Supra, Premvati Supra and Vidyavati Supra. Ekta Patna High Court first time, baki duto hoche Punjab and Haryana. wherein under similar circumstances with the similar note existing in the said state, the court has observed para 5 এর এই পোর্শনটা নেবেন, দাগ দেওয়া আছে, এই দাগ দেওয়াটা রুল 6.17 এই যে, হ্যাঁ এটা হচ্ছে পাঞ্জাব হরিয়ানা।
Page 4, just before paragraph 6.
Hmm?
Page 4, my lord, of the Patna, my lord, just before paragraph 6.
Partner play. Paragraph 6.
Yes,
Paragraph 6 টা পড়বে। In view of the above, the impugned order passed by District Inspector of Schools dated 9 December 2025 is hereby set aside. Which is the authority will sanction them? District Inspector. The District Inspector respond number 5 is directed to release family pension in favor of the petitioners to the extent of the entirety.
Okay.
That is 100%. It is para. Such exercise shall be made within a period of 2 months, 1 month from date of communication of this order. Para, it is informed by the learned advocate for the petitioner that the share of the other 2 wives, which was initially paid to the petitioner upon demise of the second wife on 13 September 2017, has been deducted from the share of the petitioner. Accordingly, District Inspector of Schools is directed to refund the amount, if any, which has been deducted from the share of the petitioner, which has been paid to the petitioner after demise of the second wife of the deceased employee.
No affidavit has been filed, no logical.
Since no affidavits have been filed, the allegations made in the writ petition are deemed to be not accurate. Dispose. So, Bhattacharya, there are other applications which has been dismissed. In the first half, I have given certain dates for hearing of those applications. Probably the issues involved in the present writ petition, as well as those have already been dismissed for default, which requires to be restored or whatever, they are filing their opposition. Until and unless the entire thing comes, a piecemeal hearing of the matter, will it be convenient for you as well as for the court? Because I suppose he will also argue.
Subject to court's convenience is question of law settled.
Okay.
There may be thousands of petitions. If the law is settled, that will govern everybody.
Okay.
That would be my endeavor to satisfy your lordship. Now, Josh Sahib বলছেন যে কোনো I don't mind if your lordship wants to fix a particular date very near, so that we can do it.
When is the other matters coming up for applications for restoration?
My lord, 2nd of March, one set of applications, and today your lordship granted us 2 weeks and 1 week to the petitioner. So 3 weeks from today, your lordship kindly fix any day, my lord, after 3 weeks from today. So all this matter can be, my lord, taken up, even subject to my senior friends.
Then again, there is a question that will come up whether in the other writ petitions, which are the applications have been filed for restoration, whether you will be filing an affidavit in opposition to them.
Except two. There are two writ petitions which were, my lord, filed in 2016, dismissed in 2016, and application for restoration was filed in 2025.
No, that is with regard to the delay you will
Yes,
argue.
yes.
With regard to the merit of the suppose it is restored.
Identical question of law.
Identical question. তাহলে বলুন ডেটটা অ্যাপ্লিকেশনস ডেজ গুলো বেশ 10th মার্চের পরে হিয়ারিং এর ডেট ফেলো 15th দেখো 15 16th
10th March
No, 10th March, those matters will come up for restoration. After 10th March, I'm fixing a date for hearing of all those matters so that those matters after disposal can be shifted to the common date.
16th or 17th?
My lord,
17th.
18, 17 I got fixed. 18.
I will get myself.
19 হবে না 19 হবে
So Bhattacharya on 18th March then?
18th March.
2 p.m. PM?
2 p.m. 2 p.m.
18 March 2 p.m.
তাহলে কেন 18 দিচ্ছেন যেদিনে হবে সেদিনে দিন এটা তাহলে কেন চেঞ্জ করার দরকার নেই ফিক্সড করে দেখা যাবে না এর তো শুরু করবে এখন সময় লাগবে
And with all due respect, Mr. Bhattacharya is appearing late. Possibly, Mr. Bhattacharya would be arguing that if it is judgment in name, then irrespective of all those matters being listed, the principle may be applied to all.
That's why on 10th March the other applications will be heard. After that a date has been fixed so that all the matters can be taken up together. That is what is suggested.
When is on 17th March?
17th March 2 p.m.
2 p.m. Lots of will make it 2 p.m.
On the joint prayer of the parties, place these matters on 17th.
The early direction manner filing application.
In which matter item number?
The respect of WPA 4. Item number 398. Item number 398. 390.
494 to 413 same matter.
अरे दाड़ा ना होता है
You are filing this for in which item?
Number 398, read petition number 4735 of 2016.
Copy given.
May I take leave?
Yes, we'll settle up.
Already filed the affidavit on the last application.
399.
400 আমার presence টা দেন।
6 appearing. I have already filed the affidavit in opposition.
Which you have filed, don't.
All right.
Which is to be filed, you say that. 398 you have filed, 399, anybody for the state?
400
I am appealing for state.
Identical
400 I am appealing for
required to file any affidavit. 403.
If it is not required, you can take the plea that is taken by the other.
Not required, well, my instruction is, but it's all are same matter, not required to file any affidavit.
Next, 400.
Melody, I am appealing for state. 400 I am appealing for state.
404.
Yes. 400 I am appealing for state.
404.
Give the slip.
404.
404 এই রে সুরিত বাবু শুধু চেঞ্জটা এটাই হবে যেগুলো ধরুন 404 যেরকম বলছে 398 বলছে তাতে যে অ্যাফিডেভিট ইন অপোজিশন ফাইল করছে সেটা নিয়ে নেবেন ঠিক আছে 398 আর 404 বাকি সেম
417 করতে বলেছে
item 412 you are filing.
I am filing on behalf of the respondent number 2 affidavit in opposition. I have already served.
412 তে you change respond number 2.
For respondent number 2, I have filed affidavit in opposition.
In 402, my lord, I appeal for the state. My lord. We have not yet received any instruction till date. So, my lord, by this time, if it is made ready, on the next day we shall
Find out from the other writ petitions what is the opposition taken. I think what Mr. Guo has submitted should almost be same.
Then, my lord, on the next date of hearing, we shall find.
Yes.
We are adopting the other
Yes.
unnecessary same.
Any other opposition to be filed? No. Copies of all these have been served?
Yes. No. Well, 403, I am applying for the system. Can you record it? 403, my lord.
Give that.
Yes, yes.
My lord, kindly consider, my lord, item number 395 as instructed by the state government, the separate opposition not necessary to file, my lord. 394 already filed the affidavit in opposition. That
At the time of hearing, you indicate that this is not required. We'll record that.
Much obliged. Much obliged.
393, I have already filed. Okay.
এইবারে বলুন Next. Mm-hmm, 2 p.m.
21.
Or refund নাকি বাড়ি
Mr. Shyamini Das is appearing for state advocate.
we are not considering now.
Petitioner is absent.
Not here.
Petitioner is absent.
Next ডাকো ঠিক আছে পাস হবে নেক্সট ডাকো বাইরে গেছে
22, 23, 24, 25, 26, 27,
দেখুন
28.
পেনশনের ম্যাটারসে আছে কিনা যদি না থাকে তাহলে ডাকবো না। আমি একটু পরে উঠবো হ্যাঁ
24.
24, I withdraw the matter, my lord.
24
Yes, my lord. Wait, wait. 24 এর repeatation number, my lord.
19369
19369. This one is the page number, my lord. Page number 3, my lord. Typically mistake, my lord. Ropa,
oh
19.
আচ্ছা মিস সায়ন্তনী
সঞ্চয়িতা দে।
সঞ্চয়িতা দে learned advocate for the petitioner submit that inadvertent typographical error has crept into paragraph number 4 mentioning the year of ROPA as 2009 instead of 1998 এতটুকু না লিখে বলতো that inadvertent typographical error has crept into the pleadings of the writ petition. She seeks to withdraw this writ petition. Liberty আছে নাকি? You will be filing it after correction?
My lord,
Okay. In view of the above submission, the writ petition stands dismissed as withdrawn. For connected applications, interim order.
ওই করে বসতে বলবে?
25,
Yes, by zero. এটা হয়ে যাবে ওটা।
26, 27,
What possible, my lord?
20?
20, 28, 29, 30. 26 to 30, my lord. এসে গেছে?
Next document?
31, 32,
No. You are taking passover for which item?
32, my lord, pass over. আরে 32 রাখতে 21 বলবো কি করে?
কত থেকে কত আপনার?
26 to 27, 29, middle এ নেই তো 29, 30, 32 পাস ওভার।
পরপর নেই?
না 31 নেই।
31, 32 পাস ওভার আপনার? 33, 34, 35, 36, 37,
38,
ওটা শুরু করো
39, চলছে না? হ্যাঁ, চলছে। 40, 41, 42, 43, 44, 45,
46.
46.
46, my lord. I am for the petitioner, my lord.
নাম্বারটা
28770. Height.
You mentioned করলে না এগুলো দিয়ে দেবো
বলে
করে দেবো 46 you are for petition.
I am for the petitioner, my lord.
What is this thing? What is the prayer?
My lord, this is the, my lord, area pension, my lord. CPF to GPM, my lord. Area pension.
Oh.
Husband is the petitioner, my lord, after wife day.
The husband exercised option under ROPA 1990.
Yes, ma'am.
Where have you stated?
ROPA 19.
ROPA 9.
ROPA 19, ma'am. CPF to GPM, my lord. Page 4, my lord. Para 5.
Oh. Where is your PPO? This is a case where you have deposited, but the effect has been given from date of deposit, not from the date of superannuation.
Yes, ma'am.
You are claiming in arrears
Yes.
from the date of deposit to the date of sanction. This is your case.
Yes, ma'am.
Awesome. By the present writ petition, the petitioner seeks for arrear pension in favor of the petitioner with effect from the date of from the date following the date of superannuation of the concerned employee till the date of
Retirement.
sanction.
First,
That is 12 September 2014.
yes.
You are for the state? আচ্ছা এইটা মনে রাখবেন সিপিএফ টি জিপিএফ এ না কোনো ইন্টারেস্ট দেবেন না আছে তো ওই এরিয়ার অফ ক্লেমটা রিভাইজ করবে এরিয়ার অফ ক্লেম ফরওয়ার্ড করবে দ্যাট ইজ অল কেন ওটা ডিভিশন বেঞ্চে পেন্ডিং আছে কখন আমি দিলেও কিন্তু খেয়াল রাখবে The petitioner contends that his wife was an assistant teacher of 41 Hare Krishnapur Primary School under Jalongi North Circuit, District Murshidabad. The petitioner's wife retired from service on superannuation on 30th April 2011. The petitioner's wife exercised option for switching over from contributory provident fund scheme to general provident fund scheme and deposited the employer's share of contribution under CPF scheme on 12 September 2014. Stop. Upon deposit of the aforesaid amount, pension payment order was issued in favor of the petitioner's wife on 22nd May 2015, giving effect of pension from the date of deposit. The pension ought to have been given effect from the date of superannuation. Hence this writ petition. Ms. So-and-so learned advocate appearing for the petitioner submits that the pension has been given, ought to have been given effect from the date of superannuation. However, the same has been given effect from the date of deposit of the employer's share of contribution.
12/9/2014, my lord.
Contribution in employer's share of contributory provident fund. Learned advocate for the state. Yes, sir.
Date of
My lord, instruct if
10 পাতাটা করে দেখো লেখা আছে। এই একটা করে দাও।
no, my lord, actually, my lord, what has happened, my lord, page number 13 of this writ petition, my lord. My lord, this date is, my lord, 12th September 2014.
ডিপোজিট করেছে।
Lord, whether, yes, my lord, deposited this amount, whether any, my lord, instruction is required. What has happened, my lord, next, my lord, 2014 to 2026, my lord, I can't, my lord.
Learned advocate.
না না 26 কেন?
Learned advocate for the
No.
state. So-and-so learned advocate for the state submits that
the
upon deposit of the aforesaid amount on 12 September 2014, the pension payment order has been rightly issued, giving effect from the date of deposit. Para.
ঠিক আছে ওটা হয়ে গেল।
It is no more res integra that the pension has to be given effect from the date following the date of superannuation or death, as the case may be. Now, superannuation, superannuation, death to get superannuation. The pension payment order shows that the pension has been given effect from the date of deposit of the employer's share in contributory provident fund, that is 12 September 2014. Accordingly, District Inspector of Schools is directed to verify the records in respect of deposit of employer's share in the contributory provident fund and forwards the same to the director of pension provident gratuity and pension provident fund. Respond numbers গুলো করে দেবে না? Who shall issue, এটা কিন্তু চেক করবেন আগের অর্ডার থেকে। Who shall issue, a format এটাই থাকবে, who shall issue a revised pension payment order in favor of the petitioner's wife, giving effect of pension from date following the date of superannuation till the date of from the date of superannuation till the date of sanction. Para. For the aforesaid purpose, the district inspector of schools shall forward the claim of arrears to the director of pension provident fund for further course of action. With the such exercise shall be completed within a period of 3 months from date of communication of this.
Faithful, my lord. Lord 45 I am for the petition, my lord, item 45.
45?
Yes, ma'am.
আবার পেছনের দিকে গাড়ি দিত
And from 21, your lord. Because my lord, the board was not properly. I am also.
board was not showing.
No, board was showing, but after 3094, it was showing 300. Sometime blank thereafter. Again.
কেন বোর্ড কেন দেখা যায় না?
What happened below the 393,
কোনগুলো possible আছে?
394, thereafter not showing. Therefore, all of a sudden from 40.
হাতে কাছে থাকলে নেব কোনগুলো পসিবল আছে বলুন? ছিল না তোর দেখে দিয়ে একবার নাকি
21.
Hello, this is in respect of Malad overdrawal in the Malad. The report has been submitted, the instructions has been submitted on the last occasion, Malad.
Look, I'm appearing for the
Direct
state
of
and I got a new instruction from DI.
কিন্তু
But the petitioner was appointed as an untrained.
Malad,
teacher.
item number 20, your lordships has already disposed of the matter. Malad, same instructions as I have seen, Malad. Malad, they have stated that petitioner was untrained, and that's why the overdrawal amount has been, Malad, made after Malad, wrong pay fixation.
Oh. Whether this has been made within the period of 1 year from your date of
Malad, I have deposited the Malad through treasury challan on. Malad, kindly see page 14. Malad, on 31st March 2022.
22.
Malad.
And when did you retire?
Malad, retired in 2022. Malad, retired from service on 30th November 2020.
22.
Malad.
23rd March 2022.
December, January, February, March.
It also be a
Within 4 months.
same matter as 20.
20 তে যেটা পাস হয়েছে সে ফিগারটা পাল্টে দেবে
Malad. Amount is different. 44,576.
ঠিক আছে আইটেম নাম্বার 20
Malad.
আইটেম নাম্বার 20 তে যে অর্ডারটা হয়েছে শুধু এর ফিগারটা পাল্টে দেবে বাকি ডিরেকশন সেম
Your lordships considered the judgment of Rafiq
বাকি
Mashik.
জাজমেন্টটা কনসিডার করে করেছিলাম ওটা ওখান থেকে নিয়ে ফিগারটা নিয়ে নেব ইয়েস ডিসপোজড অফ
Great.
But 22, my lord, I appeal for the petition. But this is also a case of an overdrawn. My lord, due to wrong fixation, certain overdrawal amount was there, my lord, which was, my lord, which was said to be deposited by the petitioner.
Deposited or deducted?
My lord, it was deposited. My pensions were stalled with further direction to, my lord, first pay and then it will be processed. So, my lord, in compelling
When
state of
did you retire and when was this amount deducted or
my lord,
deposited?
I retired on 31st of January 2024.
Hmm.
And my lord, if your lordship takes up the my lord,
PR challan?
page 29, your lordship can takes up page 29.
April 25.
My lord, that is, my lord, 16th of April 2025.
You deposited the amount.
Yes, my lord, I deposited the entire amount of 1,79,443. And my lord, that will be reflected, my lord, from last page. If your lordship turns up to last page, last part, one page, my lord, page 44, your lordship will find the, my lord, in my payment order, last part, overdrawal part, your lordship will find such and such has overdrawn amount of rupees 179,443 on account of wrong fixation, of which 17 such as have already been recovered and 0 shall be recovered, my lord. So question of recovery is already been made.
State.
May I be permitted to appear for the state respondent?
Yes. What is your submission? This is after the retirement. This is
Well, my lord, Rafiq Mashi is there. I'm also covered by your lordship judgment in Panchayat matters. My lord, issues are same.
retired on
Well, 31st of January 2024.
24. Ashun. By the present affidavit of service.
Well, this is affidavit, my lord.
Filed by the petitioner is filed on behalf of the petitioner is taken on record by the present writ petition. Refunded ja thake. Amount niye nin 179,443 together with interest. The petitioner contains that he was an assistant teacher of Hajrapukur Primary School, Kumarganj North Circle, he joined as an assistant teacher. The petitioner retired as a head teacher.
Head teacher, my lord.
The petitioner retired on
31st of January
2024 as head teacher of the state school. After his retirement, the petitioner was directed to deposit the overdrawal of salary of rupees 1,79,443 for processing the pension papers. Accordingly, the petitioner deposited the aforesaid amount on 16th April 2025. The petitioner claims that the direction to deposit the overdrawn salary after retirement is impermissible in law. Hence, this writ petition on a submission same, relying on Rafiq Masi, you are carrying the judgment?
Yes, my lord, I have the judgment. Rafiq Masi's judgment and your lordship judgments are there. But this is Rafiq Masi's judgment, my lord.
He relies on the decision of Rafiq Masi, Jathake.
And my lord, there are two unreported judgments of your lordship on the same issue.
As well as the decision.
But these two judgments, my lord?
It para 18 court করবেন. State leaves the matter to the discretion of the court. Rafiq Masi. Acha. It is Rafiq Masi court করার পরে. It is found that the petitioner retired on superannuation, retired from service on superannuation 31st January 2024. Subsequent thereto, on 16th April 2025, as per direction of the respondent authorities, he deposited the overdrawn salary. Bearing in mind the proposition as laid down in Rafiq Masi Supra, such direction to deposit the overdrawn salary is impermissible in law in the facts and circumstances of the case. Accordingly, যাতে direction থাকে to refund the said amount within a period of দেখে নেবেন within a period of 12 weeks from date of communication of this order, together with interest at the rate of 8% per annum from the date of deposit till the date of actual payment. Done an advocate for the petition.
Kindly, my name may be regularized.
Regularize করুন।
23. But the matter relates to payment of interest on arrear family pension. Father of the petitioner was assistant teacher. He died in harness prior to 81. Thereafter, my lord, scheme introduced by the government in 2010 for granting 2010 for granting family pension in favor of the widows of those deceased teachers, and thereafter PPO has been issued in favor of mother of the petitioner, page 19.
This is of 19th June. What is the date of notification? 15th June.
No, my lord, 1st November 2010.
1st November 2010.
1st November 2010.
So from that date, you are entitled to get that amount.
And before that, my lord, from that notification has been issued pursuant to earlier notification dated, my lord, 90. On 15th June 90.
You are not the widow.
No, my lord. I am the son. Mother died after receipt of the family pension.
So from which
And petitioner is the sole legal heir. My lord, page
Daughter will
18.
Not the son, my lord.
No, I am paying interest on arrear family pension, not. Page 18 is
from
the,
which date to which date?
my lord, from 13th June 15th June 1990 to the date of payment, till the date of payment.
Till the date of payment.
Yes, your lord.
Where is the notification dated that of the 2010?
But I am relying on order of a coordinate bench, your lordship. Then. My lord also passed similar orders, your lordship.
As per government servant, date has not been given.
My lord, order of a coordinate bench, your lordship, I have handed over. From 15th June, it has been granted.
Petitioner cannot state.
Arrear family pension has been paid from past April 1981. But I am claiming interest from my lord 30th June, 15th June, my lord 1990. 90.
Why so many delay? Mother died in 16.
16.
Payment made in the year 2011. You have not approached.
My lord, for that, my lord, since no third party interest has been created, my lord, pursuant to decision of the Honorable Supreme Court in Sarsam Singh, your lordship, that delay may be condoned by your lordship.
One. Yes, of course, the issued on
Daughter বলে পেনশনও দিত
level.
হ্যাঁ
Interest until it is pension.
আচ্ছা একজন জানা একজন যদি ভিডিও হাজবেন্ডের পেনশন হয়
When was the pension payment order issued in favor of the mother?
My lord, on 16 November 2011. Page 19. PPO.
And on that date, the arrear was paid.
No, my lord, thereafter arrear was paid.
Which is the date of payment of the arrear?
Paragraph 10, your lordship, 5th February 2012.
Paragraph 8.
10. 5th February 2012.
Affidavit of service filed on behalf of the petition is taken on record. By the present writ petition, petitioner seeks interest. I shall see the direction upon the respondent authorities for disbursement of interest on arrear of pension.
Arrear family pension.
Arrear family pension from the date of entitlement till the date of actual payment. The petitioner contains that his father was an assistant teacher of Thuria Primary School, District Jhargram, who died in harness on 30th October 1977, leaving behind his wife, just go through,
and one son.
Why? There are no other son?
No, my
son or daughter?
No. My page 18. I have annexed the legal age certificate.
16.
18.
18, your lordship, page.
There is no page 18. There is no page 18 in your writ petition. It ends with 17.
Actually, I'm for the state.
A legal air certificate issued by the Panchayat authority.
Page 16.
Term is 16, your lordship. Panchayat authority on 31st January 2024. Manoranjan Das, petitioner, is the sole legal heir. Yes, my lord, page 16.
File a report. Section at পঞ্চায়েতে কি বললাম wife PPO of the wife 17.
Page 17.
The leaving behind the petitioner, leaving behind his wife and the petitioner being the son as his only legal heirs. Pension payment order was issued in favor of the mother of the petitioner on 16th November 2021.
2011, your lordship.
2011. The arrear family pension was disbursed to the petitioner on 5th February 2012. এই কত বলছো কত? 5th February 2012. However, no interest was paid. Hence this writ petition. Mr. Swansol, learned advocate appearing for the petitioner, submits that the petitioner is entitled to receive the arrear interest on arrear family pension. There was delay in disbursement of the same. He relies on the coordinate decision of the coordinate bench passed in it. Karma Saran Sau versus State of West Bengal. Re WPA 5021 of 2021. Learned advocate for the state.
No instruction. Your lordship.
Why no instruction?
We have sought the instruction, but no instruction received. Your lordship.
You have sought for instruction. Learned advocate for the state seeks accommodation to take instruction. Release this matter after 2 weeks.
Man, no instruction is required. Your lordship.
If the issue has been decided, your
It's decided.
Learned advocate for the state leaves the matter to the discretion of the court. It is as per the memorandum dated 1st November 2010 issued by the School Education Department Budget Branch Government of West Bengal pertaining to pension and family pension in respect of employees who retired or died in harness prior to 1st April 1981 as per the calendar. The memorandum को start करो. Provides inter alia that the financial benefits may be given effect from June 15, 1990 or from the date of application for pension, family pension, whichever is later. In view of the above, it is found from the contents of the petition that there is delay in disbursement of the amount. এখানে delay clause-টা দেওয়া হবে। আগেই দিয়ে দেবেন আগে এই যে তারসিম সিং এর যেটা accordingly the petitioner is entitled to interest on delayed payment of the family pension, area of family pension, 8% per annum from the date that is on and from 15 June 1990 till the issuance of pension payment order. It is 15 June 1990.
From gratuity and area pension. For
the state minority, diagram number 25.
Affidavit of service filed on behalf of the petitioner is taken on record for 2019. The petitioner contains that he was an assistant teacher of Jora Nirgo Primary School, Post Jora District, Paschim Medinipur. The petitioner retired from service on superannuation on
31st July.
31st July 2016. The first pension payment order was issued on 12th August 2016.
Malat 18th August.
Huh?
No, Malat, sorry, 12th August. Yes, Malat, 12th August.
12th August.
Yes, Malat, 12th August.
The revised pension payment order under ROPA 2019 was issued on 16th August 2021. However, no interest was paid, hence this writ petition. Bagita same submissions. 14th February 2020.
Much obliged.
The payment was when was this paid? The gratuity and area pension? 30th September 2021.
Much obliged, Malat.
But I am for the petition. But the interest from
I am for the statement.
ROPA 2019, Malat. Malat, wife has come before your lordships.
Affidavit of service. The petitioner contains that her husband was an assistant teacher of Hare Krishna Konerpulli Primary School, Post Bhajan Ghat Police Station, Krishnaganj, District Nodia. The petitioner's husband died in harness on 30th May 2018. The first pension payment order was issued on 6th June 2019.
My lord.
The revised pension payment order was issued under RUPA 2019 on 6th September 2021.
My lord.
The revised gratuity and arrear family pension was disbursed to the petitioner on 27th November 2019.
So 7th October 2021.
7th October, correct.
7th October 2021.
21.
My lord.
7th October 2021. However, no interest was paid, hence this writ petition. Rest same. From 14th February 2020.
But I'm for the state.
Yes.
27.
No, this is a single PPO mala died in harness. The husband of the petitioner mala died in harness.
The petitioner continues that her husband was an assistant teacher. Same school.
Same school.
आगे जी स्कूल था हरे कृष्ण.
Yes. Same day.
Same date.
30th
आगे तो देखिए थे.
May 2018. দুটো মামলা নাকি?
Date for oh, the same person is coming.
But this is in respect of a single PPO mala. That is
That person is
same person.
same. That's आगे जांच नहीं. Pension payment order was issued on 6th June 2019. The gratuity and arrear pension amount was paid on 27th November 2019. However, no interest was paid. Single PPO से जाता के from the date following the date of death of the concerned employee till the date of actual payment. Give you.
Well, this is in respect of single PPO. Well, petitioner himself is herself superintendent.
The petitioner contains that he was she was an assistant teacher of Kodalia GSFP School, Post and Police Station, New Barrackpur, District North 24 Parganas. The petitioner retired from service on superannuation on 30th April 2023. The pension payment order was issued on 6th December 2023. The gratuity and arrear pension amount was disbursed in favor of the petitioner on 11th December 2023. However, no interest was paid. Hence, this writ petition. Now, the same from the date following the date of retirement till the date of actual payment. 8%, 8 weeks.
My name.
Mr. Bipin Ghosh, नाम रेख.
Madam.
29.
The ROPA 2019.
19.
Nothing. Himself is the employer.
ROPA 19, the petitioner contains that he was an assistant teacher. He joined as an assistant teacher in Hobi Puskorini Primary School, Village Hobi Puskorini Post Bangsipole district, Bankura. The petitioner retired from service on superannuation on 31st March 2017 as head teacher of the said school. The first pension payment order 27th February 2017. Revised pension payment order under ROPA 2019. 23rd July 2021. Revised gratuity and arrear pension disbursed to the petitioner on 26th July 2021. However, no interest was paid, hence this. ROPA from 14th February 2020 till the date of actual payment.
আমি আছি না না
But here is died in harness, mother. The petitioner's husband was the employee. Single. Single.
number? This is ROPA.
But a single PPO, my lord, died in harness.
Contains that her husband was an assistant teacher of Bhagavantipur Primary School, village Gangarampur, post office Mehrapur, police station Mothabari, district Malda, who died in harness on 10th December 2017. A pension payment order was issued on 10th July 2018. The gratuity and arrear pension amount was disbursed in favor of the petitioner on 4th August 2021. However, no interest.
2018.
Sorry, 4th August 2018. However, no interest was paid. Hence, this writ petition.
Can you regularize my name?
From date of death, following the date of death till the date of actual payment of the concerned employee. 8%, 8 week. Regularize.
But I am for the serial review interest in gratuity and arrear.
The petitioner contains that he was an assistant teacher of Belsinga FP School, post Belsinga district, South 24 Parganas. The petitioner retired from service on superannuation on 29th February 2024. The pension payment order was issued on 29th April 2024.
Paragraph 10, my lord.
The gratuity and arrear pension amount was disbursed in favor of the petitioner on 12th October 2024. 4. However, no interest was paid, hence this writ petition from the date following the date of retirement till the date of actual payment. 8%, 8 weeks.
My lord, kindly regularize.
Deepika Chatterjee, Nam.
I'm for the petition.
Motion for the state respondent.
ROPA 2019, my lord. Petitioner himself was the employee.
ROPA 19. Petitioner joined as an assistant teacher of Rameshwar Kundre Primary School, village Naricha, post Pandua district, Bankura. The petitioner retired from service on superannuation on 31st May 2016 as head teacher of the said school. The first pension payment order was issued on 3rd May 2016. The revised pension payment order under ROPA 2019 was issued on 13th July 2021. Stop. The revised gratuity and arrear pension amount was disbursed in favor of the petitioner on 14th July 2021. However, no interest was paid, hence this writ petition. 14th February 2020.
Well, I'm looking for the statement.
Petitioner contains that he was an assistant teacher of Devi Sabad FP School, Post Devi Sabad, District South 24 Parganas. The petitioner retired from service on superannuation 31st May 2020. Following the date of retirement of the pension payment, retirement of Aureas. The pension payment order was issued on 7th August 2020. 17th August 2020. The gratuity and arrear pension was disbursed in favor of the petitioner on 28th February 2021. However, no interest was paid, hence this writ petition. From the date following the date of retirement till the date of actual payment. 2020. Yes.
Published. Died in harness, single PPO. Husband of the petitioner.
The petitioner's husband was an assistant teacher of Paikpada GSF Primary School, Post Sornokhali Police Station, Krishnaganj, District Nadia, who died in harness on 9th April 2021. The pension payment order was issued on 27th May 2022. The gratuity and arrear pension amount was disbursed on which date?
16 June 2020.
16 June 2022. However, no interest was paid, hence this writ petition. From the date following the date of death till the date of actual payment. Death of the concerned employee.
Kind of regulars, man.
Yes, give your name.
So,
petitioner before your lordships is the headmaster of a primary school appointed in the year 1996. Thereafter, a criminal case has been lodged against him and subsequently he has suspended. Thereafter, a criminal case disposed of by an acquittal, order of acquittal. Thereafter, he wrote letter regarding reinstatement, but they are sitting tight over the issue. And thereafter, and now present grievance is, my lord, he has, by the court's order, he reinstate in the year 2025. Now I praying before your lordships that from 2018 to 2025, he was in suspension and getting subsistence allowances. Now I praying that his arrear salary from 2018 to 2025. The relevant documents is, my lord. The order of acquittal as page 33 to 38. That is the order of acquittal. Thereafter, my lord, your lordships will find that is acquittal. He is acquitted. In page 40, the order of this honorable court regarding consideration. Page 40, my lord. The respondent number 4 is directed to consider said representation in accordance with law expeditiously, etc., etc. Thereafter, 41, my lord, is the order. Well, kindly comes to page 42. I join on 8/4/2025, page 42. As per High Court's order, they allow me, and I join there. Thereafter, I write letter once and again, my lord, repeatedly regarding my arrear salary. But they are sitting tight over the issue. My prayer is,
my lord, I am appealing for the state in this matter, my lord. The person is working under the DPSC. My lord, though, my lord, we have as
Malik
is appearing DPSC Uttar Dinajpur. Now, my lord, so far this matter is concerned, my lord, the SI has sent the arrear bill, which is according to the DPSC is not the correct one. From 18 to 25, which you want, my lord, let the SI be sent a correct document. And most importantly, my lord, the victim girl has already filed a case for the, my lord, against the order of acquittal also. That is also pending before the Honorable High Court, my lord.
Okay.
my lord, on the basis of the acquittal order, suspension has been withdrawn. Page
Maybe my lord, suspension withdrawn, but subsequently thereafter, my lord, a criminal case has been filed against the order of acquittal, which is pending before this Honorable High Court, my lord.
I have no
Give the numbers and all, file a report.
Lordship.
my lord, we have to take instruction from the SI.
And if the appeal has been preferred, then how come the arrears have been sent?
That is also surprising.
My lord, we have to
And
take
they also
instruction because
know, Lord, if the appeal file, suspension order
withdrawal
has
of
been withdrawn.
suspension does not mean that the suspension period is, my lord, regularized. That is not the meaning of the withdrawal of suspension. That, my lord, leaving that apart.
Page
My lord,
41.
admittedly, they have not, my lord, served during that period. My lord, we have to take specific instruction as the, my lord, DPSC has already stated before your lordship that there is a, my lord, bill raised by the sub-inspector of schools. So, my lord, it is, my lord, my junior tried to contact my lord, he has not got it. My lord, kindly give us breathing time, my lord.
Affidavit of service filed on behalf of the petitioner is taken on record by the present writ petition. The petitioner seeks direction upon the respondent authorities, particularly District Primary School Council Uttar Dinajpur, to pay all arrear and current salaries. When is to retire?
No, well, I am working.
No, this is not a
When
retirement.
he is going to retire?
Retired, my lord, 27 or 28? 27.
Salaries and other service benefits and allowances with effect from January 2018 to March 2025. Mr. Swainsu, learned advocate for the petitioner, submits that.
Well, I have filed it in the month of August. Till
Submits that.
2025.
Submits that. On the basis of a criminal case initiated against the petitioner, he was put under suspension. On which date? He was put under suspension on date?
The suspension on 11/1/2018.
On 11 January 2018.
32, page 32.
Being Islampur PS case number 1117 of 2017, dated 16 November 2017. The petitioner has been acquitted from the said case. Pursuant to order passed by this court in writ petition WPA 23977 of 2024. The petitioner has been reinstated and he has already joined on 8th April 2025.
Yes, my lord.
However, the arrear salary and other statutory allowances from January 2018 to March 2025 has not been disbursed to the petitioner.
February, my lord, not from the March, my lord. It's February 2018, lordship.
No, his representation say March 2018.
No, it's
My
it's
lord,
from
January 18 to March 2025.
January 18, yes, January 18.
That is the prayer.
Mr. Bishwabrata Basu Mollik, learned advocate, appearing on behalf of the DPSC Uttar Dinajpur through virtual mode, submits that the Sub-Inspector of Schools, Islampur Circle, respond number 6, has sent the arrear bills to the DPSC Uttar Dinajpur. Sent the arrear bills to the DPSC Uttar Dinajpur. He also indicates that the order of acquittal has been challenged by the victim.
And may I indicate the number also, my lord? I have the number, my lord. CRM SPL 70 of 2024, lordship.
Appeal which is pending before this honorable court. He seeks to file a report. Top. Mr. Pinaki Dhol, learned advocate, appearing for the state respondents, also seeks to file report. Let such reports be filed by the state respondents as well as DPSC Uttar Dinajpur within a period of 2 weeks. Accession if any be filed within a period of 1 week. List this matter after
My lord, kindly
3
fix
weeks
a,
under the heading hearing.
kindly fix a date, my lord.
After
Yes,
3
my
weeks, hearing a date.
Okay.
Yes. Obviously. Yeah, the date reflected in the order. Huh? 18th March.
18 March, man.
Yes.
18 March.